And we are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is now open.
Good morning and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format due to the ongoing pandemic. Although we are conducting court in this way, all the ordinary rules of our court are still in effect, including that each side receives 15 minutes to argue with no rebuttal. With that, I'm going to call the case of Commonwealth versus Robert A. FIRTH, case number 2019 P1348, and Attorney Hagar, or is it Hagar? Hagar?
Hagar, yeah, Hagar.
We're ready whenever you are.
Thank you, Your Honor. May it please the court, Thomas Hagar from Mr. Firth. We have 3 issues on the appeal. Deal with them in order. The fourth issue deals with improper testimony. The officer was, in response to a question regarding a photograph, made a comment saying that in his opinion, he thought Mr. Firth was under some type of narcotic. He did not mention under the influence, but we view it as the same thing. They basically cited the crime by its very name. We feel that was improper. It was objected to in pretrial motion, and the question becomes: is it prejudicial error or not? We feel that it was. The comment went to the heart of the case.
Counsel, can we just
Yes.
stay on that issue for a moment? Do you agree that the judge ultimately allowed the officer to give that limited opinion?
Yes, the judge flip-flopped the pretrial. Yes, Your Honor. First, the judge did not want to be DRE, and went on to say that, but that was wrong. I mean, if the judge allowed it, doesn't make it correct. The error could be with the judge.
No, I just wanted to make sure portions of your brief, and I don't fault you for this because I do agree that the ruling was less than crystal clear, but portions of your brief seem to be suggesting that there was error in the officer giving that testimony, given the pretrial rulings. The way I thought I read them was that the judge ultimately allowed this particular opinion to come in. And I just wanted to see if you were in agreement with that.
Yeah, there was a back and forth, the pretrial, the motion. The judge first said no DRE, then went on to say, I believe, along the lines of he may have an opinion the defendant was under the influence of some drug, and allowed him to do that. I thought that was confusing. So I'm not sure where to put the blame, but the judge did sort of say that allowed.
So let's meet it on those terms, right? I mean, why is the officer, so it's an opinion, I think, but isn't the officer qualified to give the opinion? Doesn't he have a sufficient basis in this particular case?
Well, I believe he can give opinion in reference to physical observation, but I think by citing the crime by its name, I think it's gone beyond what he's allowed to do. I think.
Did he use the word influence?
No, he did not.
I thought he said he was under some type of narcotic.
Yes, my point is yes, he did say that, Your Honor. He did not say the entire under the influence, but I would say, Your Honor.
Does that? I mean, I'm thinking that the under the influence piece relates to the operating charge. Do you see what I'm saying? That you could we allow police officers and others to testify that someone is at least in their view appeared drunk or intoxicated, but we don't permit them necessarily to make the opinion that they were operating while under the influence of intoxicating liquor. So why isn't that the absence of the word influence here important?
Well, yes, Your Honor, he did not cite the entire phrase, but I say it's more of a shortened version of not colloquy, but a shortened version under the drug. So I view it because what under was used, not saying he overdosed or he was abusive or drug abuse. In fact, he used the word under. I view it as a shortened version of under the influence. It's sort of cut to the chase by saying it in a shortened version. That's how I view it.
So are you suggesting that if the officer had said he was overdosing, that would be okay?
If it's qualified to do that, that would not be an opinion relative to the ability to drive. The crime is under the influence, not overdosing or driving. So I would think that that would be slightly different insofar as observation and what he's qualified. But I think the word under has sort of a, I can't think of the right word right now, but has sort of a meaning to it beyond simply overdose. It kind of mimics I view it as a short version of the crime.
But even if it were the improper, wouldn't the fact that the officer testified to his training in administering Narcan, that he did administer Narcan in this case, and the other observations that he made, isn't it apparent from those pieces of testimony that he believed that the defendant was under the influence of a drug, specifically a narcotic?
Yes, maybe some other the other smelling salt. I mean, the pupils and all that other indication you mentioned. But I think in response to that, Your Honor, this is a violent accident, and we're not sure if any head trauma caused these symptoms. So there could have been innocent, possibly other reasons behind the symptoms that were created. It wasn't like he was pulled over and all of a sudden he came out of the car without an accident. Yes, he testified to different things. He also testified as an expert. He explained things as to what he thought would give him the opinion under the influence. But
then the jury also saw the medical records in the case, which I realize is jumping ahead to another issue, but
Sure.
saw the medical records that indicated an admission to heroin use in the same day, that there was heroin abuse as part of the diagnosis and treatment, and that other traumatic considerations had been ruled out. Would you agree on that?
I don't know what the last one, Your Honor, but I know that the first.
That the medical records didn't include a diagnosis of, for example, closed head trauma or some indication that there was an explanation other than the drug use for the defendant's appearance after the accident.
You may be right. Yeah, right. You're, I'm not sure they're looking for that, but you could be right on that. I just think regarding the issue of the medical records, the issue of drugs being done early in the morning is he only mentioned used once. He only used it 7 o'clock in the morning, 4 hours earlier. So I'm not sure how that would be effective insofar as at the time of the incident he was under the influence of heroin, and also the abuse.
What was the testimony regarding Narcan?
Or the officer indicated he overheard another officer waiting for Narcan, from what I recall.
Right,
And
but what was the testimony regarding Narcan, what it does, and what it's used for? About
Well,
Narcan, the drug.
I don't have the exact quote, but it blocks the opioids. He says a possibility of blocking the opioids, and he didn't administer it, and the person woke up. And
Right.
I sort of viewed it head trauma. It could be like a smelling salt. So he did indicate that when Narcan was used, he overheard an officer say, "Call for it." I got it. Let me go to my car. I get it. Comes back on the ground, administers it. He wakes up, and that's what I would call the testimony. But as I said, I'm just dealing with the cards I'm dealt with. I don't know if the head trauma could have been an issue as why the symptoms happened. Maybe he was like a smelling salt. You wake up, something happens. So I'm viewing on that situation is it possible there could be an innocent reason behind some of the symptoms, notwithstanding the testimony. And then, like I said, I view it as under the influence. It goes to the crime. The officer is, there's no evidence of how he was driving. All we have is the after effect of driving. We didn't see him driving it erratically or not. And then the officer, they bring some level of authority with his comments. So I think that influenced the jury.
Are you making a sufficiency of the evidence argument, though?
No, I'm making an argument that the Commonwealth's evidence is not as strong as it may seem, that there may be mitigating circumstances as to why.
But I understood your arguments to be primarily evidentiary, focused on number one on the statement that we've already talked about.
Yes.
Which is Officer Tomorrow's statement, which is an opinion, I think, but the question is whether it's qualified to give it. And the second being the certain statements in both the ambulance and the medical records, and whether those should have been admitted, right? Those are the issues that you've raised.
Yes.
The statement, again, the statement in the ambulance record appearing to be under the influence of narcotic, that again, to me, sounds like an opinion, but doesn't the case law suggest that it can come in if it's fairly connected to medical treatment?
Oh, yes, it can come in, certainly come in, but if it crosses a line into being a conclusory fact center of the jury's inquiry, then it doesn't come in. So I don't think, as I read the case law, not all opinions come in. They come in if it's an ordinary treatment, but if those treatment,
Well, wouldn't it be relevant to people who are treating this person to know that they appear to be under the influence of a narcotic? Isn't that something that, for example, if you're a doctor treating him, the fact that that was conclusion of the ambulance folks is relevant?
Well, it's relevant treatment. What question becomes, can you present it? You can, as part of the treatment. The question, can you take that? Can you then thereafter take that, present in a court of law? That's the next question.
As I understand the law, it is that if the statement is made and is related to medical treatment, then it does come in. And what I'm trying to explore, because there are cases that say that statements that say patient appears intoxicated or patient is intoxicated, that those statements in medical records come in. Even though I think one could fairly argue that it's an opinion. Is this different because it's talking about narcotics rather than intoxication?
Well, you used to do it under the influence. That's what I referenced. Did not say, overdose. Did not say had heroin or whatever. Intoxication is not really a definition of the crime. It's simply, does intoxication diminish your ability to drive? And does intoxication cause you to be under the influence of alcohol driving? So it's more the term of art, if you will, the words under the influence have meaning to them, as opposed to saying he appears to have narcotic or he's symptoms of having used a narcotic. Had it been appearing to have used a narcotic, that's different than under the influence of a narcotic. That's kind of what the difference is. So they're using the term out, which
I understand the argument. Let me ask a different question. Is it an opinion where someone has administered or witnessed the administration of Narcan and a response to that? Or is it, at that point, more fact-based than opinion?
Oh, certainly you can testify as to applying the Narcan and saying what happened. That's certainly valid. That comes in, certainly.
Well, then can't they then put in, I witnessed the Narcan, I witnessed his response, he appeared to be under the influence of a narcotic because he responded immediately to the Narcan.
Yeah, that's the Commonwealth's argument. Yes, my point is there could be other reasons why he acted Narcan the way he did. The head trauma issue. That's my argument. I agree with the point of Narcan and communicating what it does and the effects of it, and then he applied it, and this is what happened. I'm just saying, as an alternative innocent reason, possibly to weigh his symptoms and how he reacted to Narcan. So I don't disagree with the Narcan coming in and his testimony. Assuming we agree that he can testify to that, he's an expert. Mention of Narcan comes in because that's an observation. I mentioned Narcan, this is what happened. He got up, went to the fence, blah, blah, blah. That all comes in. The issue becomes is, can he testify to that, what Narcan does? And two, we're looking at the strength of the case and how the errors influence the case. Do we not take in consideration? There could have been innocent reasons why he acted. He exhibited the symptoms that
if he's trained in the administration of Narcan and he testifies that he's administered it a dozen times, can't he testify to that? Can he testify both to how Narcan operates and and what he did on that particular case? I thought he doesn't have to be a police officer to testify to that, does he?
Probably not. No, I think that my brother's side of the case, which the judge uses their discretion to allow someone to testify as an expert, it was an EMT, but they're licensed and they had like several hundred cases. So I'm not sure if there's really a cutting off point of 10. You can't, over 10 you can. I just think that this person had not done much drug stuff since about mid-90s. And so I just think that he's not as resume is as big as other people, as like as other issues. And I also think that, I'm not sure, I didn't really phrase this in my brief, but I don't know to what extent that a person who could potentially be a plaintiff in a case down the road can be an expert in a criminal trial. I'm not sure how that would fall here. I didn't mention that in my brief per se and how to frame that in my mind, but I just feel like this person is a victim in the case, he's off-duty officer. It could be a potential plaintiff down the road in a civil case. Can he be his own expert witness? And that's something I want to add now. I didn't put my brief per se on how to really frame that, but I just think that he's somewhat limited experience, off-duty officer, potential plaintiff in a case. And I know it's a judge's discretion, as my brother, Tony Sullivan, mentioned in that case, but I just don't think he should be allowed to testify as an expert witness.
I noticed reference to a photograph that was admitted as an exhibit that showed the defendant near a fence. Was that included in the record appendix?
My record, no, I did not. Sorry, Your Honor, the photograph.
All right, is there a way that you can submit it?
I can call the court and find out. Yeah, sure.
No one, well, I guess we'll ask the Commonwealth too, but where you're making an argument that your errors resulted in prejudice, I'm not sure how we can really assess that without seeing the entirety of the evidence.
Okay. Oh, yeah. I thought that yeah, the comment regarding hanging on the fence was stricken, but yeah, I can call the court. Yes, Your Honor. I'm sorry, I did not clear the record appendix.
Yeah.
And just lastly, I just think that basically all the evidence, all the issues, I'll rest my brief on the issues, but I think collectively together they create prejudice error because you allowed evidence that came in that probably shouldn't have, as I discussed. And I think it had more than slight effect on the jury, given the fact there was a licensed police officer and also the authority from a medical staff. So I would argue that it caused prejudice error. And for the questions, I rest my brief.
Thank you. Attorney O'Sullivan.
Good morning, and may it please the court, Shane O'Sullivan for the Commonwealth. Officer Tomorrow's opinion, which he offered in this case, that the defendant was under the influence of a drug, was testimony that would have been obvious to the jury based on Officer Tomorrow's testimony as to his observations of the defendant and his actions, more specifically the decision to administer Narcan and the defendant's reaction to it. However, even though that opinion would have been obvious to the jury, the opinion itself was not improper. The trial judge did ultimately, although it was confused at times, did ultimately rule that the officer would be allowed to offer that opinion if he laid a foundation as to his experience.
Mr. O'Sullivan, did the judge allow or can you show me where the judge allowed the witness to testify specifically to the type of drug, which is something initially the judge explicitly denied the Commonwealth's ability to do?
Sure. So the ruling was that the judge, and I think it's, I want to say it's on page 27 or 28 of the transcript, and forgive me if that's my best guess here. But the original ruling was that the ruling was that the officer was allowed to testify to being under the influence of some drug, was the quote unquote some. Now, Officer Tomorrow did use the word narcotic, so to that extent there is a variance there between, and if the court feels that that maybe went beyond what was allowed, I would suggest that to the extent it goes beyond what was allowed, it was somewhat minor, and it was also, I would suggest, still based on the officer's experience and qualifications. I would also suggest it would have been obvious to the jury, given the officer's testimony as to Narcan and the effects of Narcan, and
Can we stop there? Because we have plenty of cases where there's much more developed expert testimony about Narcan, what it does. It doesn't have any effect on certain types of drugs. It doesn't, there's developed testimony about what it does do, how it does it, what it doesn't do. And there are even some cases that I've seen expert testimony showing that it's now used by hospitals as sort of a presumptive test for the presence of opiates. So, but none of that came in here. So how are we to imagine that the jury would have known about Narcan, which seems to me not a matter of common knowledge?
Well, the officer did testify to, and it maybe didn't go as, his testimony probably didn't go as far as what the EMT gave in the Booley case, which is cited in the Commonwealth's brief, but the officer did testify the effect of Narcan on an overdosing person, that it would, I think, cancel the high was the way that he kind of summed it up, and that the defendant had a reaction to the administration of it. So I would suggest that although it may be the description of the effects of Narcan and its purpose and how it's used probably wasn't as extensive as Booley, I think it still offered enough information for the jury to make the inference that it had the desired effect on this particular defendant and what the purpose of the Narcan is for. And Officer Tomorrow, you know, he was.
Can I ask, are we, and this isn't quite on the same point as Judge Wolohojian, but it's related. Are we to some degree talking about semantics here? About the opinion that the officer actually gave? If the officer said, in my opinion, he was driving under the influence of a narcotic, that's no good, right?
Well, I think I can answer that, but maybe not as directly with a yes or no. That would be improper, right? Because only because the officer didn't maybe see this defendant driving or wasn't with him driving. I think that what you're getting at, Your Honor, is that it under Canty, and I think Canty's kind of it's improper for the officer to say under the influence so that his driving was impaired. And really the driving was impaired portion, I think, is the part in Canty that is.
So he could say he's driving under the influence of a narcotic, but he's not driving while impaired by a narcotic?
Yes, because impairment is the ultimate issue. So that's what can't be testified to. In an OUI drug case, we have this.
This is pretty semantic then, right? I mean, he says he's under some type of narcotic. He doesn't say under the influence of some type of narcotic, and he doesn't reference driving, but he talks about what he observed and says he's under some type of narcotic. So a couple extra words and we got a problem.
Yes, I think it, but I think the cases show that there's a fine line there. I mean, we allow.
And is that because it's not necessarily that one is an opinion and the other is not an opinion, but rather one is an opinion that touches upon that usurps the province of the jury, which is the ultimate finding that the jury is supposed to make?
Yes, exactly. That
one of them is guilt, and something less than that you would say is not guilt, right?
Correct.
So if we have something that comes close to guilt, such as, let's say, he's under some kind of narcotic, that's still subject to the ordinary test of whether something is unduly prejudicial. In other words, its prejudice outweighs its probativeness.
Sure, it always is.
Yeah.
Sure. But that's an abuse of discretion review, and I would suggest.
And do you think that's affected in any way by the fact that the person is testifying with the, let's say, cloak of expertise that comes from being a police officer?
Well, not necessarily. I think so long as the officer's qualified to give that opinion, then it's acceptable. And I would suggest that to whatever extent it may be prejudicial, it's extremely probative. In an OUI drugs case, whether the defendant appeared under the influence of the narcotics. This officer, I would suggest, had the relevant experience in being a narcotics officer, being trained in Narcan, having administered it multiple times in the past. And so I don't believe the judge abused their discretion in admitting that limited opinion. I would also note the judge did give a cautionary instruction, which essentially tracked the cautionary instruction in the Gallagher case, which this court described as greatly diminishing the risk of any prejudicial effect. So that was also a proper step taken by the trial judge, and a wise one to attempt to diminish any prejudice.
Can we skip to the medical records for a moment?
Yes, Your Honor.
We continue. This is not the first case that I've seen where an opinion of intoxication or under the influence of a narcotic has gone in through a medical record, and we don't have a case that says it's okay to have an opinion that someone's under the influence of a narcotic, do we? In our medical record.
Not that I'm aware of, Your Honor.
We have, what is it, Palicidios or something like that is the case that talks about intoxication, right?
For alcohol, I believe.
Yeah.
So, and the way that I would answer that kind of issue, Your Honor, is I think it comes down to reliability, right? Is it reliable or not? That's, I think,
well,
really
how do
the
I
question.
know? I think maybe that's right, counsel, but I am troubled by this because I don't know who's given the opinion or what they know about whether somebody's under the influence of a narcotic, and yet it goes before the jury.
We don't, but there's an assumption with medical records. I believe there's an assumption with medical records that what is in there is reliable because it's used for medical diagnosis and treatment. So I think, like, when you get back to
I agree, our cases say that, and to the extent it's an observation, the person smelled of alcohol, the person could not stand up, the person had glassy eyes. I think that's right. We assume the reliability, but when you flip over into an opinion, based on what I've seen, this person's under the influence of a narcotic, and we don't know who the heck wrote that or whether they have any experience in determining whether somebody's under the influence of a narcotic. I find it troubling, don't you?
No, I don't really, because again, I don't believe that it would make it into the medical records. So essentially, it's this, and I'm sorry if I'm kind of keep going back to it, but I think the underlying principle here is that it would not go into the medical records unless it was good enough for doctors, nurses, medical professionals to do the important business of saving people's lives in a hospital. If it's good enough for them, it's good enough for us lawyers. So essentially, that opinion would not go into those medical records unless it was a reliable
that to me flips our law of allowing in expert testimony on its head. We have Daubert and we have Lanigan for exactly the purpose of trying to filter out what kind of opinion ought to be allowed in a courtroom, and the notion that it all goes out the window because it's in a medical record from someone we don't know what kind of experience they have. To me, that flips our law on its head.
I don't believe so, Your Honor, because Daubert and Lanigan again are about reliability. That's why we have Daubert and Lanigan, is to determine, is this expert opinion reliable? The person who's offering this opinion qualified to give it?
Do they have a background in what they're saying? And have they used a reliable methodology? And a judge sits over the top of that and says, not good enough or good enough. And here you're saying none of that gatekeeper role applies. If it gets put in a medical record, it comes in.
I would suggest yes, because the reliability is established by its inclusion in the medical record. So a reliability under Daubert Lanigan would not be necessary. And I think that the foundation of the medical records exception is consistent with that.
Would you agree that if the medical record said something like the person appears to have suffered a gunshot wound, that although that embeds an opinion to some degree that the cause of the wound was a gunshot, it's closer to a straight observational, visual observation than, and perhaps less complex a one than where it says the person appears to be under the influence of narcotics?
Maybe potentially, maybe potentially. Maybe, you know, a wound, I think, also could be something that could be, you know, pretty complex, but potentially. And the other, you know, aspect of it too is, I think what we let in through medical records, it isn't always as simple as a direct observation. I mean, if there were lab results from a blood test or something, that could come in through the medical records exception. Now, that's an extremely complex scientific finding, yet that still comes in. So you know, I do think that the complexity is maybe not as much of a factor.
Wow, that's an interesting point. So frequently we see blood test results in medical records and they come in, right? He had
Correct.
0.2 alcohol in the blood or whatever. But do we ever see, we ran a DNA test and his DNA was on the gun. We don't do that. If that were in a medical record, we wouldn't allow it in.
Well, yeah, well, I'd hope there'd be no reason for the hospital to do that, you know. And again, and the reason why, but even if there was, or with the blood test example, and again, this goes back to kind of, I think, the basis for the medical records exception. That's also one of the reasons we allow this in is the courts have recognized we're not going to be pulling in the lab workers from the important work at the hospital to come testify to their you know, how they came to this conclusion. So that's also underlying the basis of the medical records exception as well. And I think that's an important consideration to keep in mind.
Okay.
I see my time's expired unless there's any further questions that Commonwealth with RESTO.
Let me just check to see whether there are. All right, thank you. It's an extremely interesting case, and we've been helped by
And we are live.
Good morning and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format due to the ongoing pandemic. With me this morning are Judges Englander and Hand, and my name is Gabrielle Wolohojian. Although we're sitting in this format, all the ordinary rules of oral argument apply, including that each side receives 15 minutes to argue with no rebuttal. With that, I'm going to call the case of Commonwealth versus Luis RESTO, case number 2020P0330. And Attorney Ryan, we're ready whenever you are.
Good morning. May it please the court. My name is Molly Ryan Strehorn, and I represent Luis RESTO. I would like to start by first acknowledging that the preferred method for a motion for new trial, or for an ineffective assistance of counsel, is through a motion for new trial. This meets the exception for two specific reasons. The first being that it was there was a factual basis that appeared indisputably on the record. And the second one is that the relief requested is not a motion for new trial. This was a reversal sought on insufficient evidence. The trial attorney, let a legally insufficient case go to the jury.
If we were to disagree with you, I'm just trying to understand the relationship between your two arguments. If we were to conclude that the evidence was sufficient, does that end the story on the ineffective assistance of counsel claim?
It does, Your Honor. They're both interrelated.
Okay.
And can I just ask, maybe Judge Wolohojian's question answers this question. I'm sorry, go ahead. I'm sorry to interrupt.
It's okay. As you know from the brief, the issue is the elements of constructive possession. The first is the knowledge element. And even though in possession cases, especially constructive possession, prior case law is an imperfect guide because they are so factually specific. But in my research, I have yet to find any case that could attribute a statement from the defendant of an admission of a prior actual possession to be imputed to knowledge of possession in this case.
Wasn't his statement fairly interpreted as an admission to distribution?
Correct, for an uncharged crime. It was an admission. He said to the arresting officer, I just got rid of 50 bags of heroin.
But he also tied that to location as well, right? Because he said, you're not going to find anything in my bedroom. So he tied his distribution activities in some manner to the apartment.
It is a little bit disputed on the record whether or not the actual part of the bedroom was part of his statement. During the redirect, the assistant district attorney used his police report to put in the statement. And in the police report, he said, you're not going to find drugs anywhere because I just got rid of 50 bags. So
okay, so let's assume that, so let's take the you weren't going to find drugs anywhere piece of it, right? So that would seem to, in my view, undermine your argument about his control over the apartment in it as a whole, because when he says that, it seems to indicate he thinks he knows what's in the apartment, right? And so why, if someone makes a statement like that, why doesn't it bear on constructive possession, even when the person's not in the apartment?
I think it actually goes to the knowledge element. And the most helpful case on analyzing the knowledge element is Commonwealth v. Montevallo. So in that case, as you were on the panel for that case, the knowledge element was very distinct in relationship to what the defendant could see in plain view versus what was hidden in a closet in a safe. And so in this case, with the defendant saying, he essentially has knowledge that there's nothing in the apartment because in his personal opinion, what he had is gone. And so he doesn't know that there's drugs hidden in a common area kitchen in a cereal box near a refrigerator. And so without proof that he actually has this knowledge, and with a very lax investigation to determine who else lived and had access to this common area, there is no proof of knowledge based on the facts of this case.
Viewing the evidence in the, go ahead.
Go right ahead.
I was going to ask, in the light most favorable, couldn't the jury have concluded that Mr. RESTO lived in the apartment alone, based on what the landlord said, the location of the items that were found that belonged to Mr. RESTO in the kitchen, and the police observation of what did or didn't appear in the other bedrooms?
Could you repeat that again?
Sure. More simply, viewing the evidence in the light most favorable to the Commonwealth, would you agree that the jury could have concluded that Mr. RESTO lived alone in the apartment, that he was the only occupant of the apartment?
Right. So in the light most favorable, we need to actually have evidence that we're going to look at. And in this case, what the police did was a very lax investigation. So when you look at all the statements that were attributed, or the evidence in this case, when the officer said, I can't recall, you can't shape that into it didn't exist. So the best example of this is Commonwealth v. Boria. So in that case, especially noted in footnote 5 in that case, the Commonwealth benefited from having a dearth of evidence about who else lived there. There was no evidence about who was on the lease, any utility bills, no explanation of who purchased based on the confidential informant, no description of the furniture, no description of the apartment. And so all of the officers that testified in this case had very significant areas that they checked. So for instance, Detective Thibodeau, he just looked at RESTO's bedroom. And so when questioned about, did you see anything else? He's going to say he didn't, because he didn't look for it. The only officer who testified that he looked at the entire apartment was Detective Martinez. And when cross-examined for him, his direct quotes were, Nobody on the search team asked if anybody else lived there. He didn't recall if he saw anything else. He can't say for sure if anyone else lived there. There was stuff in the other bedrooms. He doesn't have an answer about articles that didn't come back to RESTO. So in this case, you're not going to find what you don't look for. And the officers didn't look beyond the very narrow part that tied Mr. RESTO to his bedroom.
Did some of the other officers, well, they all looked in the kitchen. They looked in RESTO's bedroom. Was there testimony that any of the officers looked in the other bedrooms other than what you've just described?
The only officer who said that he looked at the entire apartment was Detective Martinez. So Detective.
Well, but that's not answering my question. Did any of them look at other bedrooms?
Well, that's a good question. Nobody testified that they looked at other bedrooms. They couldn't recall the other bedrooms, though when pressed, they admitted that there was a bed in other bedrooms. There were materials in other bedrooms, but for instance. Well,
wait, there were materials in other bedrooms. The sole evidence there were materials is the one officer who testified they looked at the entire apartment and he saw quote unquote stuff. Was there any other evidence of that?
So Detective Martinez said stuff, and Detective Frisch took photos of Mr. RESTO's belongings. But there's no evidence that anybody else went into the other there was nobody testified that they went into the other bedrooms. They didn't testify that they saw just Mr. RESTO's bedroom that was occupied. There was, and even when they did this breaking down the doors, they broke down the doors because they didn't know if anybody else was going to be there. So they just didn't investigate. They're not going to find anybody else's stuff because they didn't look for it.
The question in my head, and this is a well-constructed argument. The question in my head is sort of what has to be shown? Your argument is, in essence, the Commonwealth had an obligation not just to show that the defendant was there and that there were drugs there, but that no one else was there.
Well, we all know that constructive possession does not have to be exclusive. So it's not that they had to show that nobody else was there, but in order to prove the elements that Mr. RESTO had dominion and control and a particular relationship with drugs that were found in a common area in a cereal box hidden on top of a refrigerator.
All right, so but what it seems to me your argument sometimes veers into asking us to do is to imagine the perfect case, whereas what we need to figure out is whether the evidence was sufficient to permit a jury, taking the evidence in the light most favorable to the Commonwealth, to conclude beyond a reasonable doubt that the defendant had knowledge and the ability and intent to control. Right. So on knowledge, why is it that the defendant's own statement that he knows what is not in the apartment sufficient to permit the jury to conclude, together with the evidence that he's the only person who lives there? There's clear evidence that he lives there. There's evidence that attaches him to the kitchen itself because there are the documents on the kitchen table. Why isn't that evidence sufficient to permit a juror to conclude that he would know what drugs there may or may not be in the kitchen?
I recognize that no case is going to be perfect factually, and I think it's when you compare the evidence that was available in this case with other case law that tip the scales for sufficiency. So in the Commonwealth's brief on page 16, they cited this case, Alcantara. And that was a helpful case to explain when you have multiple people in a living situation, how you can tie a particular relationship to the defendant. So the drugs in that case were also found in a common room, in a bathroom. But the drugs were particularly found in a medicine bottle that had the defendant's name on it. and then also underneath it. So
Were there multiple people physically located or present in that apartment at the time the drugs were found?
I don't remember factually, but it was clear that there were multiple people who had access to that bathroom. And the defendant actually argued that he was set up by somebody else. I don't know at the time of the arrest if there were other people there, but clearly the case law says that even just presence near drugs.
Okay, so if the jury, and we're not looking at the case, as you know, ab initio. We are coming in after the fact, and we have to view the evidence in the light most favorable to the Commonwealth. So if we have to accept that the defendant was the only person who lived at the apartment, and I recognize there's conflicting evidence on that point, but we have to set aside the conflict now on appeal. If we have to accept that he's the only person who lives there, why is the evidence not sufficient?
Well, you're asking me to accept something that is not factually relevant in the evidence of the case, because they couldn't recall whether he was the only one. So you're asking me to pretend that he's the only person who lives there. And
well, no, I'm not asking you to pretend. I mean, are you saying that no juror, the evidence did not permit that finding?
oh, yes, I'm absolutely saying that there was no evidence that he was the only one who had access to that common area kitchen, because testimony that you can't recall is not the same as. Okay, so you're trying to push me into a different thought process. So I don't think I could make this argument if this was a single bedroom apartment. For instance, even in Pratt, which is cited in the Commonwealth's brief, page 16. So in that case, you have a one bedroom cottage, and you have a married couple who lives there. And in that case, you find little bottles of meth inside toiletries. It was in plain view. It clearly linked the defendant to the area in that cottage. But then when the police went and searched the area, the yard around the cottage, they also found some. So they were able to tie what was in the yard to what was in the cottage. So clearly, it's in this case, you have evidence that this is a one bedroom apartment he's the only one who has access to the kitchen. Then as his appellate attorney, I would have to find a different argument to bring before this court. But that's not what we have here. We have a 3-bedroom apartment where the landlord testified that he rented it to 3 different people. The police came in and had to take down every door. But then when they narrow their scope to just look at Mr. Resto and just look at his belongings, and then when questioned about who else could have lived there or had access to that kitchen, they can't recall. They don't know. There wasn't any evidence that they looked and, I'm sorry, I see my time.
No, go right ahead.
But in this case, you can't give the Commonwealth the benefit when they're not gonna find what they don't look for. And that's the facts that you have before you in this case.
It's not really, I'm sorry.
Go right ahead.
It's not really, I mean, sometimes your argument strays into a lack of investigation sound to it. But I think your argument is the Commonwealth needed to prove that he was the only person in this 3-bedroom apartment, and they didn't prove that.
It definitely goes back to the earlier elements of knowledge and dominion and control. So to prove those, you almost have to present who else had those capabilities. And so these drugs were not found in his bedroom. And when they're found in plain view in your bedroom, you kind of assume that you're going to have knowledge and dominion and control. But the things that were in his bedroom were not things that are illegal in this case. The thing that was illegal was found in a common area kitchen hidden with plain view and a cereal box.
Let me see if there are any other questions. Thank you very much.
Thank you.
Attorney Salois.
Good morning. May it please the court, Abigail Salois on behalf of the Commonwealth. Where the jury heard sufficient evidence to support the convictions and the defendant's trial attorney was not ineffective when he declined to renew his motion for a required finding of not guilty, The Commonwealth respectfully asks this court to affirm the convictions. If I may, I'd like to focus most of my time on the sufficiency piece, but I'm also happy to answer questions about the ineffective assistance claim, of course. So as we know, the standard is whether the evidence at trial and reasonable inferences therefrom, viewed in the light most favorable to the Commonwealth, were sufficient to sustain the convictions. Although more than a particular link is needed, in cases where there's a common area, exclusive dominion and control over the apartment was not required. And in this case, there was sufficient evidence that the defendant had dominion and control over the apartment and the contraband found there. For example, as was stated earlier, the defendant admitted to selling heroin. There was indicia of drug dealing on the defendant's person at the time of arrest. And as my sister mentioned, these things alone were not illegal, of course. However, there was expert testimony presented to the jury about how these things are indicia of drug distribution, excuse me. There was also a respirator mask, bags, and $964, and another person's DTA card discovered in the defendant's bedroom. There was no indicia of personal use, and the amount of narcotics was consistent with distribution. And as was mentioned,
this argument, which was also well constructed, is that the evidence that he was a drug dealer is sufficient to provide an inference that drugs found not in plain view in an area that he did have access to were under his possession, custody, control, whatever the right language is not, he had knowledge and dominion and control, right?
yes, Your Honor.
Perhaps combined with his own statement that he stored drugs that he used in his distribution operation in the apartment.
What's the closest case, in your view, to those facts? We know he's a drug dealer. We don't have anything that directly shows, there's no plain view, we don't have anything that directly shows knowledge of the drugs with which he's charged with possession, but the evidence is sufficient because we know that he's dealing with drugs, if you will, in that apartment. What's the closest?
So Your Honor, as was mentioned earlier, these cases are so incredibly fact specific and they're all different in little ways. But I would point the court's attention and urge it to rule as it did in the Alcantara case and the Pratt case. And in this case too, there was enough evidence viewed in the light most favorable to the Commonwealth that the defendant lived alone. As was mentioned, the police officers found only the defendant's documents, clothing, and possessions in the apartment.
No, you had an officer testify that he saw stuff in another bedroom and without any further explication or explanation of that.
Yes, no, that's correct. What I meant to say, maybe I didn't say that clearly enough. The only identifying documents, clothings, and possessions were identifiable to the defendant. There was stuff.
No, there were DTA documents, right? There were these cards.
Yes, and there was testimony that from the expert witness that drug dealers frequently accept DTA cards as payment for narcotics, and that the police knew that the 2 DTA cards that were discovered did not belong to people that lived there. They had other addresses for those individuals. So that is really further support for the defendant's guilt in this case. But the landlord on the defendant's only witness was the landlord. And he testified that, let me just find the correct language here. So the defendant's landlord testified that he rented the 3 bedrooms to 3 different people, including the defendant, and that 2 other people lived in the other bedrooms. And that's at, I just want to make sure I'm getting it right here. I believe that's in transcript volume 2, pages 41 and 42. And at the same time, the on cross-examination, the Detective Sergeant Martinez, the landlord told the police officer, I'm sorry, that no one lived on the third floor except for the defendant. So it was within the jury's purview to weigh this evidence and decide what was true. I mean, they could have listened to the testimony and decided that when the landlord said he, other people lived there, that he was not being truthful, and they were certainly not required to credit
The
that.
statement from the landlord to the police officer, if I recall, went in without objection, right?
Yes, Your Honor. So it was certainly within the jury's purview to disbelieve the landlord's testimony, and that sort of ties into the ineffective assistance argument, and that seems to be why it would make sense for Attorney Sergeant not to renew his motion, because if anything, I think his witness was harmful, certainly wasn't helpful to his case. So he could have decided not to renew his motion after assessing the strength or weakness of his witness's testimony.
Seems to me to be helpful to his case. He had somebody come in and say 2 other people lived in those bedrooms.
That might have been helpful, perhaps if, for example, he moved to introduce a lease that had other people's names on it. And then, of course, on cross-examination, he had a police officer saying that the landlord told him something different, which goes to the veracity of that witness. So where the defendant's evidence didn't deteriorate the Commonwealth's case, a renewed motion for required finding of not guilty would have been denied, and counsel wasn't ineffective for choosing not to file one.
Who was it who testified to the landlord's prior statement?
It was Detective Sergeant Martinez.
Okay. The landlord was not cross-examined on that point?
Don't believe he was. I don't believe he was. He testified on direct exam that he, at the time of the arrest, was living on the 2nd floor with his family. But then the detective said that he told him otherwise. And I would point out too that there was testimony that Detective Sergeant Martinez had known the defendant for 3 to 4 years and had known him to live alone. So the jury was permitted to take that into consideration as well, and weigh that into their determination.
He testified, I knew him to live alone.
Yes.
Yeah. I mean, there's also evidence that 2 other people walked out of the, literally people observed immediately before they executed the search warrant, 2 other people walk out of that building with him, right?
Yes, Your Honor, that's true. And there was testimony before the jury that those people were found to have indicia of drug use on their person. They had small amounts of heroin, consistent with personal use. They also had what was described as a works kit. And Sergeant Nato provided expert testimony to the jury that the evidence that was found on their persons was consistent with personal use. So the jury could have inferred, again, of course, in the light most favorable to the Commonwealth, that these individuals were personal users and customers of the defendants.
The actual statement, I just went and looked at the record, and it seems to vary a little bit from what's in your brief. The statement that I read that the defendant made is that you won't find anything. There's no reference to a bedroom. You won't find anything. I just got rid of, or he just got rid of 50 bags of heroin. Is that right?
There was 2 transcript sites in my brief. One was at page
190 and the other one is at 214.
So it could be possible that one said bedroom and one did not say bedroom. I think that's my.
I didn't see bedroom in either one. That's why I'm asking.
I can quickly look for that for you. But while I'm looking, I'll also add that, as I mentioned earlier, the jury could have made a reasonable inference that the defendant lived alone, and in which case that wouldn't matter if the drugs were, you won't find anything in my bedroom or you won't find anything. So
And the basis for inferring that he lives alone as being a reasonable inference is the statement by Martinez that he knows him to live alone.
yes, and also the statement by Martinez that the landlord had told them that no one else lived there. I'm sorry, I'm just looking for that transcript site, and I'm sorry about that.
I think on 190, there's a reference a
Yep.
little bit lower in the page to the bedroom, although it may not
Yep,
be.
here it
exactly
is.
what
So it's
Judge
at,
Andrew was looking for.
Thank you, Justice Hand. I see here.
Oh, there, I see bedroom now. I'm sorry. How did I miss that?
That's okay. You guys read a lot of things. It's at line 12 to 15. And
14
then I
to
do
15.
believe that later it wasn't specified as bedroom, but I, you know, again, in the light most favorable to the Commonwealth, it would have been reasonable for the jury to
I
infer
see.
that the defendant was the only occupant of the apartment.
Okay. He does say you won't find anything in his bedroom, doesn't he? Thank you.
I don't have anything else. Are there any other questions from the panel?
I don't see any. Thank you for your
So
argument.
just in conclusion, the Commonwealth respectfully asks the court to affirm the convictions, and thanks, Your Honors, for your time.
We thank both of you. It's an interesting case. We've been helped by your argument on both.
And we are live.
Good morning. Welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format due to the ongoing pandemic. Although we are conducting oral argument in this fashion, all the ordinary rules of argument apply, including that each side receives 15 minutes to argue with no rebuttal. With that, I'm going to call the case of Commonwealth versus Luther Lee Williams, case number 2020 P0709. Attorney Steele, we're ready whenever you are.
Thank you. Good morning, Your Honors. Lisa Steele for Mr. Williams. May it please the court, I'd like to begin with the Brady issue. The trial court found, and the Commonwealth conceded, that the Commonwealth did not provide trial counsel with 2 reports showing that the firearm used to shoot Somerville, the victim in this case, was twice used after the defendant was incarcerated. The trial court found it was material and it was exculpatory. There was a Brady violation here. The only question remaining in the motion for new trial was prejudice. The trial court credited Attorney Horgan's affidavit that if he had these materials, he would have used them. They had not been specifically requested, so we're dealing with the substantial risk the jury would reach a different conclusion, or that this would have been a real factor in their deliberations. And it would have, because it puts flesh on the skeleton of there being another culprit, that either Somerville lied or he was wrong. Now, the trial court says, well,
How does it undermine Somerville's testimony?
it undermines Somerville's testimony because it puts flesh on the specter that the true culprit is actually out there. That he's, as I said, he's lied or he's mistaken. Now, the trial court says, well, the jury would have just found.
But it gives, I will credit the argument that it gives the defense counsel something to say, right? Defense counsel can work with the fact that if Williams is the culprit, who's firing his gun, right? But does it really undermine Somerville? Somerville says, I knew the guy, I knew he had a kid, we had small talk, we spent a minute together and he shot me in the leg. And the fact that the gun turns up someplace else, it seems to me doesn't, and isn't this what the judge was getting at? Doesn't really address what Somerville had to say.
But it does, Your Honor. absent these reports, the jury knew that no one had searched Williams' house. The jury could well have concluded that he disposed of the gun, that he, that he threw it in the river, or that it was still in the apartment somewhere. Now we have a question for the jury of why is this gun still on the street, and is Somerville wrong? Now, Your Honor, that moves us directly into the second issue, which has to do with this familiarity and the significance of it.
Can we just stop for one moment? The standard for prejudice is, in your view, what?
The standard for prejudice were on the substantial risk that the jury would reach a different conclusion, or that this evidence would be a real factor in its deliberations.
Thank you.
So let me move briefly to the second question. Is the identification really strong evidence? The revised Gomes instruction, the final Gomes instruction, directs the jury to look at familiarity in the context of family, of friends, and of longtime acquaintance. Now, I note that that instruction has changed from the original Gomes language, which had just told the jury to look at whether these people were acquainted, and if so, how well. That language was narrowed after commentary, after the Standing Committee's recommendations. To affirm this case would eviscerate that narrowing. It would mean that in any case where there's any sort of asserted acquaintance, the jury should consider it. What the court had in mind were cases like the more recent Thomas case from this court from March of 2019. The bartender says, this person was my customer for 10 years, regular customer. That's a longtime acquaintance. Howard from this court in 2020. They lived in the same building. They saw each other every day. They're neighbors. That's a longtime acquaintance.
Does this argument, are you making your argument regarding the failure to ask for special instruction? What is this argument going to?
This is going to the ineffective assistance argument, which is part of the trial court's conclusion that the identification was strong, is also part of its finding on Brady. So to that extent, the two arguments are intertwined.
So it ties into the prejudice piece of your Brady argument. But what part of ineffective assistance of counsel is this?
Trial counsel, we assert, was ineffective first for not researching or considering a good faith misidentification defense. He says that, trial counsel says that having read Dr. Berman's affidavit, if he'd read it, he would have raised this in addition to the defense he already raised. It goes to investigating this defense, to being able to make a tactical decision about the defense, and to not presenting it, and in not presenting it as an alternative argument, to rebut the Commonwealth's claim that, well, yes, Somerville is an admitted liar. Yes, he lied to the police. Yes, he lied to multiple judges, but he's not lying about this. And the idea that he cannot possibly be wrong because of this casual acquaintance. And that's, Your Honor, is my concern.
All right, so you're not arguing that Somerville was not permitted to make an identification.
No, Your Honor, he can make
Okay.
the identification, but the jury lacks the tools to weigh it. The jury, in the revised Gomes instruction.
Well, the jury did hear the basis for Somerville's knowledge of the defendant.
It does, but it's still, Your Honor, not being given the tools absent an expert to understand it.
Is this an argument that it's always ineffective assistance in any case of identification, not to have an expert on the defense side to talk about these issues?
No, Your Honor. Again, I'll go back
So help me understand the line you're drawing, because this expert is not saying, I've looked at all the evidence and in my view, the identification is so shoddy it ought to be thrown out. I'm not suggesting even that an expert could give that, but it's not going to Somerville's identification. It's going to identification general. You're saying it's ineffective assistance not to have someone testify about the general concerns about eyewitness identification.
No, Your Honor, I'm not saying that. What I'm saying is that trial counsel, when you have a case with this nebulous an acquaintance, it was ineffective first not to investigate whether familiarity was an issue and whether there was a potential for good faith mistake. And having done that research, having talked to someone like Berman, not to present it in this case. If you've got a case like Matos from 2019, where the identifying witness is the defendant's mom, you don't need an expert. That one's pretty straightforward. Again, the Thomas case from 2019, the identifying witness has known this person for 10 years. Probably don't need an expert. Here, however, we have a much more casual relationship. We have these people have seen each other in a social setting off and on for about a year, 6-7 times. They've only actually directly had a one-on-one conversation, maybe twice, maybe for 5 to 10 minutes.
Why do you need an expert for that as opposed to, why isn't that all just ordinary fodder for cross-examination?
Because the other Thomas case, the Supreme Judicial Court in 2017, explains that familiarity is complicated and perceptions of familiarity are counterintuitive. My concern is the jury is making the exact same mistake that the trial judge is making and the prosecutor is making in believing that this tangential acquaintance is so significant that it's not possible, that it's futile to claim that he made a mistake. It can't be futile. If it's futile in this casual situation, then it eviscerates the revised Gomes instruction, which is limiting that consideration.
So in order to have prevailed on this argument, or at least to show us that the judge abused his discretion in denying the motion for new trial that raised it, wouldn't we need a clearer statement from the proposed expert saying exactly what you just said?
I don't believe so, Your Honor. The problem is that the expert, there's only certain things the expert's allowed to say. He provides a framework. Our case law is very clear on that. He can't reach the ultimate issue of, is this witness making a mistake? He can say, these are the factors, having exhaustively reviewed the record. And he talks about all the things he reviewed. These factors are significant. This is what I would have testified to. Attorney Horgan, who can opine about the strength of this argument, says, yes, I would have done this. And the trial court does not reject Horgan. He doesn't say, I disbelieve Horgan. What he says is, I, the judge, don't think the jury would have accepted it, but we don't know that. Mr. Williams was entitled to that.
He says more than that. He also says that he thinks that Horgan did the best he could with what he had, which I think goes to the, the fundamental question is whether failing to get the expert manifestly fell below what would be expected of an ordinarily competent attorney, right? That's your argument is ineffective assistance of counsel. This guy, by not getting an expert, failed to do his job to a level well, below, manifestly below what would be expected. The judge says, I think he did the best he could. So he says more than what you said.
But he does that, Your Honor, based on two errors in reasoning. His conclusion about familiarity, which is not based on the record and not based on Dr. Berman's materials, and his conclusion that you can divide an incident that takes less than a minute into these pre and post stress observations so you can discount stress, you can discount weapon focus. He's overly weighing the familiarity, and thus he's coming to this conclusion that this is strong evidence and it would have been futile to present the alternative. Williams, as it sat, Williams was left without an answer to the Commonwealth's basic theme that Somerville was a liar, but he didn't lie about this. And he couldn't possibly be wrong because they knew each other. And the jury needed a framework to understand why casual acquaintance, you can still be wrong. You can still make that spontaneous mistake that Berman talks about. And having made that mistake, you can be consistently wrong thereafter because you've made the mistake and you believe it.
So
That's
when we, maybe you can turn to the prejudice, the second prong of Sufficient, because, and tell us how the judge erred. And because, you know, you do have the victim's identification. It's contemporaneous within seconds. You have the text messages with the defendant's nickname, which certainly would put him there, permit that.
Your
You
Honor,
have his cell phone
Your
or
Honor-
his girlfriend's cell phone next to the victim. So why is it in that context how is it that we would find that the judge erred in concluding in denying the motion for new trial on the idea that there was, you know, some legs to the mistaken identification theory?
Somerville's identification is the case. The text messages don't come from the defendant. They come from Miller.
Sure, but they name the defendant.
But in 29,000 text messages, the bulk of them between Miller and Somerville, this name never comes up before. There's no point where I can find that Miller is brokering deals on behalf of anybody, never mind Snipes. This just completely comes out of the blue. So I think you can discount those text messages.
And the defendant's girlfriend's cell phone?
The cell phone, Your Honor, is broken. Well, the first thing is the cell phone is found on the street broken. We don't know how long it's been there. We don't know how it got there. If you listen to Somerville, what Somerville says is the assailant is reaching out and grabbing his neck chain with hand one, and he's got a gun in hand two. Where does that cell phone come from? Now, Somerville says he's digging in his own pocket for drugs. That probably explains how the white cell phone gets there. But the black, there's no explanation for where the black cell phone comes from.
Maybe when he pulled out the gun?
But there's no evidence. I mean, Your Honor, there's nothing. Somerville never says, I saw it fall, I heard it fall.
Well, the evidence is that there's a cell phone in the middle of the road where the incident just took place, and that it's William's girlfriend's cell phone.
It's somewhere in the road, Your Honor. We don't, because it's not, the photographs don't show it in relation to things. It's hard to tell if it's in the travel lane or over more towards the gutter.
Where the trial judge makes the decision on prejudice, do we owe it deference?
I believe you do, to the extent that the trial judge's conclusions are not themselves an abuse of discretion. And again, that's going to get me back to the problems with his view of identification in the dividing the incident and then the familiarity.
Does your experts, Dr. Berman's affidavit specifically say that that cannot be the case? Does it not say that the effects of stress are on subsequent identification?
I don't believe he says that, Your Honor. There is absolutely nothing in the research that says you can divide up an incident less than a minute long this way.
Okay, but looking at,
because it's wrong.
I'm looking, excuse me for interrupting you, but looking at Appendix 54, which is paragraph B, I think, of number 4, up at the top, maybe the third line down, the research shows in contrast that extreme stress has a debilitative effect on subsequent identification accuracy, but that doesn't rule out the possibility that an identification based on a moment prior to the exertion of extreme stress might be exempt from that, does it?
It does not directly, Your Honor, but I think that's a misreading of what Berman says. And I think it's a misreading of the research. I think it's a misreading of the stress instruction. It's an incident less than a minute long.
So what in Berman's test submission, it wasn't testimony, submission, bears on the strength of the victim's testimony that when he drove up to the house, he saw, I forget the guy's name,
Miller, I believe.
Miller's daughter, and the defendant on the porch.
I don't think he directly addresses it. He does talk about the effects of expectation. He talks about the suggestion, and he talks about this idea, the memory, as we know from the instruction, the memory is not a video. You can't take the part of the video.
Sure, but my question was, what in Berman's submission would bear on that particular testimony?
The closest I could say, Your Honor, is record 52, paragraph 3, the last sentence, where he says that he's gone through all of these things and that he believes these factors are things that increase the likelihood, are present in this case and increase the likelihood of false identification.
But in that sentence, he specifically refers to subsequent identifications.
I think, Your Honors, what he's talking about is the identification procedure, not the spontaneous misidentification. That's paragraph 5. The question is, what does this totality of things do when he's called upon to make the identification, not the accuracy of his perception in the moment?
Okay, let me see if there are any further questions. All right, we have your argument. Thank you. Your time has expired. Attorney Wendell?
Yes, Your Honor. Good morning, and may it please the court. Assistant District Attorney John Wendell for the Commonwealth. I think the most appropriate place for me to begin this argument is with addressing the standards of review and burden of proof. I'd just like to begin there by emphasizing the standard of review is abuse of discretion. And because the motion judge was also the trial judge, he has particularly broad discretion in ruling on this motion. And
but surely he doesn't have the discretion to deny the motion if an objective view is that the jury would have, and here you may have to help me with the exact language because there's multiple different formulations of it, but it's along the lines of you cannot say with confidence that the outcome would have been the same. Words to that effect, right?
Yes, Your Honor, but also no. And I know that sounds weird, so let me explain. The question here is not, is there potential prejudice from the failure of the Commonwealth to disclose exculpatory evidence? The question is not, was counsel ineffective? The question is, did the motion judge abuse his discretion in reaching the opposite conclusion based upon the information that was presented to him? And I emphasize that because much of the basis in the defendant's appellate brief for arguing an abuse of discretion is information that was never presented to the motion judge. So to put it bluntly, if it's not before the motion judge, it can't be considered on appeal to determine whether the motion judge abused his discretion. So
what I'm concerned about, let's start with the Brady issue. I'm concerned about the motion judge had before him that there were, and it's been conceded by the Commonwealth, that there were reports that the gun had been used twice after Williams was in custody, right? That was before the motion judge, right?
Yes, I conceded that the evidence was exculpatory, that it was in the Commonwealth's possession, and that we failed to disclose it.
Okay, so that's all before the motion judge. So then the question, so there's been a Brady violation.
Yes.
And the standard for that is?
Because the evidence was not requested specifically by the defense, the question is whether that evidence could have permitted the defendant to create a reasonable doubt where none would have otherwise existed. That's at least one way it's phrased. That's how it is in to Cherry.
Boy, I thought I read a case yesterday that rejected that standard, said we're getting rid of that standard and we're going someplace else.
That's the way it's phrased into Cherry and the recent matter of
Cherry
the
is the one at 412 US, 412 Mass.
I
Yeah.
believe.
Hold on, let me pull it out.
Let me. Cherry is 412 Mass 401. Yes, that's 1992. It's also the standard recently used in the matter of a grand jury investigation, the recent 2020 case on the subject of exculpatory evidence and when the Commonwealth must disclose it.
What's the citation for that?
That's for, I apologize. It was a slip opinion at the time of the brief, Your Honor. It's a 485 case, 485 Mass case. I forget the specific page. I apologize.
That's okay.
In any case, that is the standard as it's phrased in those two cases. It's also phrased in other cases as may have had a real impact upon the jury's deliberation. That's another way of phrasing it. And I would submit that that's simply not the case here. There is, of course, the point that these two individuals know each other. I'll come back to that in addressing the ineffective assistance point. But fundamentally, we have evidence here the gun was used after the defendant was incarcerated. But that's not particularly impactful given that the gun was never recovered in the first place. What the jury had before them was the Commonwealth is accusing this man of shooting this other man, but they don't have the gun despite the fact that they arrested him 2 days after the fact. So and this was all known. The fact that some other individual has the weapon after the fact simply means that some other individual acquired it.
Well, that's
or at
one
least
inference.
it can.
The other inference is Williams didn't shoot him. The guy who's shooting the gun later is the guy who shot him.
Sure, but that same inference
which would have been available to defense counsel to argue had they known the evidence, which the Commonwealth didn't provide.
But
Right.
it's also available.
Let's like say that maybe, and we don't know, but maybe it needed to be explored whether, for example, Miller was identified as the shooter in the subsequent incidents.
That would be a point of particular interest, but there was
Exactly.
except even they're not necessarily.
But the test isn't necessarily, I don't think.
Well, no, it's not. My point here is that because the weapon is not recovered from the defendant, the defense can already make the argument, well, if he's the shooter, why doesn't he have the gun? Why is the gun somewhere else?
But it's not as strong an argument as if, he's making that argument and we know for a fact that someone else used the gun to do shootings.
I respectfully, Your Honor, I would have to disagree with that. I would suggest that the fact that the gun was never recovered means that assuming that the jury chooses to believe the victim, that simply means that he disposed of the gun by giving it to another person as opposed
right,
to
but you're
presupposing
and taking as a given that the jury's going to believe the victim, where they might not if they knew that someone else used the gun.
They could just
so
as
that's
easily.
That's the problem, I think.
This is the fundamental weakness of the Commonwealth's position on this, is whether this is actually material, what impact this has. But the fact of the matter is the jury credited the victim's testimony that the defendant
they didn't
was
have
the
this
individual
information.
No, but they had the information that the gun was not recovered. The argument was available that he's not the shooter, because if he's the shooter, where's the gun? So that same argument, that same situation avails itself. If he's the shooter, why does someone else have the gun after the fact? The answer to that is he gave it to somebody else, or he chucked it somewhere and someone else found it. There are multiple different ways that this could be reviewed. And so we fundamentally come back to that, the point that the motion judge made, which is the point that I made to him, that these two individuals know each other. So fundamentally, it comes down to a question of the victim's honesty here. And that was the argument that was presented by both sides at trial. The victim is honest, no, he's not. So with that, I'd like to turn to that subject of the identification, the strength of the identification, whether or not a good faith mistaken identification defense was available. And the first point I would make is that the judge is not required to credit defense counsel's affidavit, nor is he required to credit the defense expert's affidavit. He's not required to credit anyone's affidavit. He has.
Did the judge discredit those affidavits though? Did he make a statement one way or the other?
I would say that he implicitly discredited defense counsel's affidavit with regard to, I would have done this other thing had I known this information was available. I would suggest then that based on his finding that the defense counsel, trial counsel did the best he could have done with the situation he had. So given that, I can only say that he's allowed to discredit that. There's therefore no proof that this is not a tactical decision. And so that forestalls any.
I don't understand that argument, counsel. I mean, we have an affidavit from the only person who can tell us saying it wasn't a tactical decision. And you say he doesn't have to credit it, but you can't get to the converse on this record.
No, you can't, Your Honor, but that goes back to the burden of proof. Because the burden of proof in a motion for a new trial is on the defendant, if the defendant fails to present credible evidence, the Commonwealth wins the point. If the defendant has to prove that it was not a tactical decision. It's not that there's a question of whether it's a tactical decision or not, unless it is a.
Well, as Judge Hand points out, he didn't discredit what was said on that subject, right? I think he wrote his opinion on the assumption that counsel's representation was acceptable.
Perhaps he did. I suggest that he seems to have implicitly discredited the points on tactical decision, but of course, much of my argument in my brief assumes that it was, in fact, an oversight on defense counsel's part. And so that turns to the question of whether this was actually an available defense or not. The good faith mistaken identification was actually an available defense based upon the evidence that was presented to the motion judge. And I have to emphasize that point, based on the evidence presented to the motion judge, because there was no evidence presented to the motion judge that would in any way undercut the idea that this identification made immediately upon the victim's arrival at Miller's house, that was in any way problematic. There's nothing in any of what was presented to the motion judge. So Dr. Berman's affidavit, for example, it says a weapon can impact the reliability of an identification. Yes, that is absolutely true. High stress can impact the reliability of a subsequent identification. Yes, that's absolutely true. Nothing in there says, and it can have a retroactive effect on something that happened prior to the introduction of the weapon or other stressor. It's simply not in the affidavit.
Meaning that it doesn't really apply it to the facts of this case.
Not per the language in the affidavit. The language in the affidavit says, I have noticed several factors which can impact the reliability of an identification. And here, let me articulate them for you. I agree with all of the factors that he enumerated as being factors that affect the reliability of identifications, but there's nothing in the affidavit that says, and they impacted the reliability of the identification in this case. Nor is there anything about the stressor or the weapon that says it could have impacted the reliability of an identification made prior to the introduction of the stressor. And I am aware that an expert is not permitted to testify at trial to the ultimate issue. The expert is not permitted to say at trial, no, this identification from this witness is unreliable, but that rule does not apply to affidavits in support of motions for new trials. He could have very easily said in his affidavit, based on my review of Somerville's identification of Williams, I do not think that identification was a reliable one. I think it was prone to mistaken identification. That would be absolutely appropriate in an affidavit in support of a motion for a new trial. So fundamentally, there's nothing in here that undercuts the reliability of this identification. So a mistaken identification defense just wasn't available. I'd like to note in the reply brief, the defense attempted to address this. 2 sentences here. Dr. Berman was well aware of the facts in this case. If there was any justification in research for dividing a less than a minute long incident into pre and post stress/weapon perceptions, then he would have mentioned it. That's not how it works. Because it's not in the affidavit, that information was not in front of the motion judge, and therefore the motion judge cannot have abused his discretion for failing to consider that evidence. So I do see that I'm running a bit short on time here. There are no further questions. I think I've adequately summarized my argument and would rest on my brief.
Let me check. Nope, I don't see any. Thank you both for your arguments. It's an interesting case. We've been helped by both sides' arguments, which were very well. Conducting court in this fashion, all the ordinary rules of oral argument apply, including that each side receives 15 minutes to argue with no rebuttal. With that, I'm going to call the case of Samuel D. Perry versus Christine Arroyo and others. Case number 2020 P0412. And we're just going to wait for Justice Englander to reappear before, there we go.
Sorry,
before we get.
Desmond just appeared at my door. I realized I'd left it open.
Oh, and with that, we're going to get going. And Attorney Weltman, we are ready whenever you are.
Thank you, Your Honors. Good morning. May it please the court. My name is Jeremy Weltman. I'm here for the plaintiff appellant, Mr. Samuel D. Perry, and I've been watching all morning long. So I think we get to switch gears from your criminal docket here and move to a civil case. The underlying litigation is Mr. Perry's appeal of a 2014 ZBA decision granting what's called a conditional use permit, or a CUP, under Article 32 of the Boston Zoning Code to the appellee Glenn for commercial development next to Mr. Perry's property, consisting of the consolidation of 5 separate lots and the development of what is a major retail, office, and housing project to be constructed over what was existing green space and directly adjacent to Mr. Perry's lot. A jury waived bench trial took place in May and finished in November 2019, and the Superior Court entered judgment in favor of the Glenn defendants, appellees, affirming the decision of the ZBA to grant Glenn's the CUP for the project. Mr. Perry's appeal followed. What we really see in this case, the issues in this case is broken into 3 major subparts, and the first part has a couple of subparts underneath it. So if the court will allow me to, I'd like to take each issue individually, of course, subject to your questions. The first major issue we see is that we believe the Superior Court erred when it affirmed the decision of the ZBA to issue a conditional use permit to the defendant appellees in a number of distinct ways. The first is that—
Before you get into that issue,
sure.
Can you clarify for me what your understanding of the standard of review is for that decision?
The judge will have to have been clearly erroneous, Your Honor.
Clearly erroneous, is that with respect to the findings of fact?
The findings of fact and conclusions of law, Your Honor, we believe if there's a manifest error in the application of the law, it's also subject to dismissal.
Are you talking about the appellate standard of review here, or are you talking about the standard of decision that was to be used down below, which was in some ways also a standard of review?
Sure. The standard of review below, we believe, was a review of the ZBA's decision as to whether it was whimsical or arbitrary, capricious. That's a familiar standard. We believe on appeal that the standard we have to show is that the Superior Court committed clear error of law or manifestly misapplied the facts to the law. the law to the facts, excuse me. So we do see there's two different standards of review.
But ultimately, if we were to determine, so the error of law would be that the judge erred in concluding that the ZBA did not act arbitrarily or capriciously.
The error of law would be the analysis of Article 32 and how he came to the conclusion that the ZBA did not act arbitrary or capricious, Your Honor. Our position is that Article 32 and Section 32-6 is really the crux of the claim here, of the manifest error by the judge. And what we argue in our papers is that when you look at Article 32, Section 32-6, you have to go back to typical rules of judicial construction, right? So judicial construction of zoning bylaws is determined by ordinary principles of statutory construction. There's no difference here. To this end, the court should endeavor to interpret a statute to give effect to all provisions so that no part will be inoperative. Of course, the statute here, the G-Cause statute, Article 32, Section 32-6.
So, counsel, I'm going to cut through this for myself, and
sure.
my colleagues may want to run backwards because let's assume for a moment that I agree with you that A and B have to mean two different things. Wasn't the evidence that was before the judge that there was going to be more water collected by the proposed design than is currently collected for infiltration purposes?
Then the current situation, yes, Your Honor.
Okay, and did the judge make a finding to that effect?
I don't believe he did, Your Honor. I believe that the finding is that as long as there's a no harm certificate as to Part A, Part B is automatically. No,
he dances around that a little bit. But is there something? It's the way I understand the fact as presented by both of you. Currently, there's a fair amount of water that drops on this site that gets sent into the city sewer system, and less will be sent into the city sewer system if they do the design that is shown on the plans. Am I misunderstanding that?
In a 30,000 foot view, Your Honor, you're absolutely correct.
So then how is it that anyone could infer that you're worse off? Which is what, the second part, worse off, I'm sorry to use shorthand, but B of Article 32-6 or whatever it is, talks about a negative impact, hold on, I've got it right here, on no negative impact on groundwater levels within the lot in question or adjacent lots. If we're collecting more water for infiltration purposes, how can we have a negative impact? How could B be implicated?
Because, Your Honor, the argument presumes that the status quo or the base of what they're comparing it to, what HW Moore compared the situation to, was the condition that was illegally created by the applicant himself over a number of years, right? So we're not talking about what was a natural green sump in the area. We believe that the argument should have been allowed at the ZBA.
Seems to me that's a legal argument that has to do with how you analyze Section 32-6B in determining what is in fact a negative impact on groundwater levels. You say you got to go back to a baseline from 20 years before.
No, what we're saying, Your Honor, is that if you're going to make an analysis,
in fact, the project isn't going to have that negative impact. Your real argument is the negative impact happened 20 years earlier when they got rid of the green space and the pervious material.
No, the negative impact we're arguing under Section B is that it should be a separate analysis to take into account the fact that a baseline might be different in each scenario. Our argument is that if the ZBA had properly analyzed both subsections of 32-6, both A and B, it would have required them to actually break down and hear argument on behalf of Mr. Perry at the ZBA hearing, which we said didn't happen.
Why does that make sense? Why does it make sense to construe this standard to allow someone to set a baseline other than before and after the particular project that's under review?
We are not allowing someone to set a different baseline. We're simply asking that the ZBA hear arguments from adjacent lots as to why that particular baseline might be different than the other one next door.
But
We say-
isn't this illegal? I mean, I'm offering you the opportunity to explain to me. It's a legal question, it seems to me, which is when they use the word negative impact on groundwater levels, I would read that to mean before and after the project.
And during the
And
project.
you're saying, no, it's after the project versus sometime many years earlier.
What I'm saying, Your Honor, is that if you were to, an applicant go to ZBA under GCOD and the ZBA is doing what it's supposed to do under the statute, that it should make a separate assessment as to both prongs. And the judge did here in his decision is he says, if you meet subparagraph A, you automatically meet subparagraph B. And he goes even further and he says, in fact, even crediting the evidence we find here, I don't think it's ever possible for someone to prove that you can't meet part B. To me, that analysis, whether it's a legal or factual analysis, goes to the crux of the issue here, which is that he being the Superior Court, is reading out subparagraph B in his analysis. Whether or not
Is there a definition of groundwater levels that, as that phrase is used in section 32-6?
You know, I looked at the definitions the other day and I didn't see groundwater levels specifically defined. I'm looking.
Is that a term of art? Where do
It
we
is,
go
Your
to
Honor.
find, where do we go to find, in your view, the definition of that term?
Well, if you'd like to look at the Boston Groundwater Trust, Your Honor, they are the entity that's charged with really maintaining groundwater levels. And they do a good job of explaining what that really means. And you'll see that in the amici, and they draw it onto the amici brief, that, you know, they provide what they believe is definition of groundwater levels based on.
And you're now talking about it as a measurement. It can be measured. What is the groundwater level today? A certain number of feet below grade, I think is.
Yeah, Boston City base, Your Honor, absolutely right.
Okay, so that may or may not have a relationship to the measure of 1 inch over the surface area of a particular parcel or piece of land, right? It seemed, in your view, they're two separate measurements. Is that correct?
Absolutely, Your Honor. It
Okay.
absolutely is.
So, I mean, presumably, hypothetically, the groundwater level could remain the same even if you collected no ground rainwater on a particular parcel. And likewise, the groundwater level might drop even if you collected 1,000 inches of rainwater. I guess it's possible that there would be a connection, and it's also, but they're not necessarily the same measurement, correct?
That's correct, Your Honor.
All right. So, and this ties back to Justice Englander's question. What was the evidence of the groundwater level pre-project? Let's just take as the site existed when they looked for approval for the project, both at the situs of the project and on your client's lot. And what was the evidence of the groundwater level, how that would change? In other words,
The only evidence we have at the trial, Your Honor, is to what the groundwater levels actually are. We came through Mr. Grassi, who's an architect, and we go through our brief why he shouldn't be, you know, the utmost authority on engineering perspective of groundwater levels. But I think this even goes beyond your question, which is whether or not there are numbers before and after. The burden of proof at trial was clear that it was upon Mr. Lynn's lap and table to prove that the number before and after wouldn't have changed based on this.
So are you saying there was no opinion that that the groundwater level measurement, as opposed to the rainwater collection figure, that the groundwater measurement would change as a result of the project?
There was, Your Honor. We have, Mr. Perry had submitted evidence of an engineering report that suggested that before this project actually took place, but after the allegations, he says, were they capped over the parking lot next door for parking. that the water actually had dropped to the point that he had sufficient evidence of damage to his piles, that portion.
But that was pre-project.
So that was that was after 2006 when the pavement went in and capped off the area, but pre-construction.
Right. The pavement, it was before the project that's under review here, right? That drop is not as a result of the proposed project that was in front of the ZBA in the 2014, I think, proposal, correct?
The proposed drop that I referenced just now is not directly tied to the building that went up. However, we do say it was tied to the activities that predated the building, which should have been considered by the ZBA in contemplating subsection B.
Okay, so I guess the answer to my question is there was no evidence of an expert opinion. There was no expert opinion as to what would happen to the groundwater level, not the rain, the groundwater level as a result of this project, either on the project site or the adjacent lot.
That's correct. No evidence.
And in your view is that's fatal because the burden was on the proponent of the project.
Yes, Your Honor, that's correct.
But why can't they satisfy that burden by putting in evidence that they've met the requirements that are imposed on them with respect to the design of the infiltration system? Why doesn't that satisfy their burden and then shift it to someone else to say that's not going to be good enough?
Sure. Well, first, Your Honor, respectfully, that's not what the standard says. Excuse me, Article 32-6 doesn't say there's a shifting of burdens. It says that the burden is on the applicant. And, we believe that it's, in order to satisfy 32-6, you can't just show Part A and automatically assume Part B, or else there wouldn't be the word and between the two subsections.
I mean, if I put in evidence that says, I'm going to meet the infiltration standard of A, and my expert says if I meet the infiltration standard of A, that there should be no negative impact on groundwater, and that's enough, right?
No, it's not enough, Your Honor, because you have to take
Why
into
not?
effect.
Surely that's got to be enough.
Okay, because there's two provisions in Article 32-6. A, you meet the mathematical requirement, which you talked about, but B is also that the project results in no negative impact of groundwater levels within the lot and the
Right,
adjacent
but
lot.
I just put in B, and I don't know if that evidence was there, but B is, if I do A, then there should be no negative impact on groundwater levels.
But that's not what the statute says, Your Honor. All it says is
That's an opinion from an expert that meets B. B is satisfied because I did A. That's got to be logically something that an expert could say.
It could, Your Honor, and then on cross-examination, the same expert admitted to doing absolutely no investigation as to the groundwater levels before and after the project. So without any investigation, any evidence whatsoever, what you see before the court and what happened in the ZBA is that as long as you have a certificate from an engineer, it says mathematically my model hits the 1-inch collection capture rate, that it per se can't have any negative effects on adjacent lots.
Well,
if that was per se, why Your Honor, respect.
Did the expert testify the way that I just described? I confess that I have not dug into the transcript. Did he say this meets the infiltration requirements, and as a result of meeting the infiltration requirements, there should be no negative impact on groundwater levels?
The expert, Your Honor, Mr. Keeler for HW Moore, testified that the A piece was absolutely met, but that he says he could not say with any evidence that B was met. That's his testimony, Your Honor, because he did no investigation whatsoever in that respect.
No, the last part doesn't satisfy me, but okay, I'll take a look at the testimony.
Let me see if there are any other questions. Seeing none, thanks. Your time has expired. Well, now
I did have one other question, if I might.
Sure.
Has this project been constructed?
It has, Your Honor.
Okay.
So if we were to agree with you, what would be the relief that you would seek?
Well, Your Honor, we believe that the case the finding of the Superior Court should be dismissed. We should believe that the case needs to be remanded to the ZBA for proper review. And quite frankly, if it building went up without a proper certificate of CUP, conditional use permit, we believe it should come down. Those are the rules. The building went up, an at-risk permit. The building, the owner understood the risk when he went up, that this was under appeal. And we believe that the relief here is within the equity powers of the court.
All right, thank you. Attorney Barry?
Need to unmute.
I knew I was going to do that. I apologize.
And Attorney Weltman, you may want to put yourself on mute.
Thank you, Your Honor.
Good morning, almost good afternoon, Your Honors. My name is Julie Barry. Obviously, I represent the Glynn defendants in this case. I can leap off right into the discussion that we were just having. And it's not correct that there wasn't any evidence before the court concerning groundwater levels at the property. Mr. Brewer, the professional engineer who testified on behalf of the Glynns, provided testimony at trial concerning the Boston City base levels. He actually provided an exhibit that is Exhibit 18 that shows where the system is to be located relative to these groundwater levels, and that based on readings from the Boston Groundwater Truss device that reads water levels in the area that's in the public alley that is adjacent to both properties, the 10-year reading average of groundwater height was 5.5 feet.
Okay, so that's what that does is give us a baseline. Was there evidence like I described from someone who said, this satisfies it satisfies a volume capture requirement, and therefore there will be or should be no impact on groundwater?
Yes.
Where will we find that?
You can find that in the opinion not only of Mr. Keeler, and I can point you to that directly, which would be I can get you the site, Your Honors, in just a moment. Mr. Keeler testified that by meeting the calculation, with that calculation approved by the Boston Water and Sewer Commission. This isn't just an exercise with an engineer submitting a calculation to the ZBA and there's no scrutiny of it. It had already been reviewed by the Boston Water and Sewer Commission, which found that it infiltrated at least 1.0 inches of rainwater over the entirety of the site. The calculation was made in a very conservative fashion. It didn't just take in the area of the project itself, which is approximately.
So I'm going to get technical with you because okay. I think it's important. I don't think that calculation tells you B, okay? And the reason is that if you don't know whether you're in fact capturing all the water that is striking the site, then all that's telling you is you have the capacity, you have a volume that you can collect in your infiltration system. But if you're only if in the present circumstance, if you will, before project, you're collecting over 100% of the site, and you're collecting 50% of the site in the post, you're losing 50% of the rainwater. So A doesn't tell me that you have B. And so, you follow what I'm saying?
I do, but that's not the circumstances here because none of the rainwater was being captured at the site prior to the project. It was all
everything is going into the sewer. Where are we going to find that? Because some still isn't being captured post, right? Some of these downspouts are still going into the sewer system.
One downspout in the front of 45 Hereford Street connects directly to the sewer system, and there's evidence that shows that sending overflow to the sewer system is an appropriate thing to do, but it's only the one downspout.
Okay.
The downspouts to the rear. The issue is the plaintiff has suggested that there's no evidence of capture here, which is completely incorrect. The roof system, there's evidence from Mr. Brewer, and all of the plans depict that as a result of the 2000.
Can I just slow you down? This is very helpful. Let me just slow you down. So Brewer will tell us how the current system works, and that the vast majority of the rainwater falling on the site that can be captured is captured and sent to the infiltration system.
Correct.
Where is the baseline of what the site is like pre-project, so that we know post-project is better than pre-project?
Well,
Where's that?
the baseline here can be established via the analysis that Mr. Brewer provided of the 10-year average of groundwater height in the area, the height of Mr. Perry's piles, which is at 5 feet, and
That's a different point. Where is it?
But
where
it's
is-
actually tangentially related, if I may, Your Honor.
Yeah, but if that's your best answer, then
No,
okay,
it's
I'll
not
listen.
it's not my best answer.
Right.
Right now, everything is going to the sewer. As
And
designed by
where is that in the evidence, counsel?
If you, it's in the judge's decision in the findings of fact at paragraphs 38 and 39, which provide the citations to the record for the testimony.
Oh, outstanding.
It's undisputed. It is an agreed fact.
Thank you.
That
Thank
there
you.
was no system at this property. So anything that this project collects is going to be more than what's collected now. And the
Right.
facts show.
So is there an opinion? I have a whole bunch of questions for you. So is there an expert opinion that, well, let's start first. You would agree that the judge, the way the judge read this regulation, he thought that satisfying subsection A satisfied subsection B.
I would agree with you that he found that, but I don't think that it's just from the text of the article.
Okay, well, regardless, he seemed to have used that analysis. So he made, I take it, no separate findings, factual findings to satisfy subsection B. And if he did, if you claim that he did, then I'm going to ask you to show me where they are.
In the judge's findings, which are agreed.
Well, part of them were agreed facts and part of them were not.
Right, I'm talking about the ones that were agreed. Which if you go to, in addition to the fact that I just mentioned, in paragraph 36 is the fact concerning that it is good engineering practice to provide for overflow to the stormwater system. In paragraphs 44 through 47, 48, and 49, it discusses how the system captures the water.
I saw all those.
Drains and outlet drains, sends it to the stormwater infiltration system.
Right. So I guess the answer to my question is the judge made no specific findings regarding subparagraph B.
I don't think that's correct because.
Okay. Well, let's just assume then, except for the moment, because your time is limited. So we don't want to get caught up. Let's just assume that when I read that opinion, the judge's decision, I didn't see any specific finding with respect to the requirements of subsection B. So can we turn to your interpretation of the requirements of how to read subsection B or how to read section 32?
Sure.
-6.
Yes.
You know, to state the obvious, there is a word, short word, but an important word at the end of subsection A that says and.
Yes.
What do we do with that word as a matter of ordinary statutory construction?
Well, what you do with that word is analyze the other evidence or review the judge's other findings concerning the evidence and the
I'm talking about statutory interpretation.
Statutory interpretation?
Not the evidence. I mean, ordinarily, we have a ton of cases that say and means and. It's a conjunction.
I'm not disputing that.
All right. So assume we were going to follow that law. How then can we read this section 32-6 in the way the judge did?
You have the testimony from Mr. Brewer, Mr. Keeler, and Mr. Grassi, all of whom testified that based on their more than 3 decades each of experience permitting these conditional use permits for these types of projects, that if the criteria of section A were met, which provides that a sufficient amount of water is captured and directed to the system, and the presumption is that the project meets B.
Well, with all due respect, I'm not sure that that's legal precedent, and it's certainly not binding legal precedent. So let's accept that they said that. Would you turn to the next page of the section 32-6? I'm looking at least what I'm looking at is what's on the, well, it's the last paragraph of section 32-6. So it's, at least on the version I have, the top of a page that's above 32-7. And it starts with the words, notwithstanding the above provisions of this section 32.6. Are you with me?
I am. I'm right there. I'm reading along.
Great. So then, I mean, I don't know, maybe I'm reading this wrong, but what this seems to me to say is that notwithstanding the above subsections A and B, if a project falls within, and then it lists a bunch of overlay districts in the North End, Fort Point, Waterfront, Harbor Park District, Bullfinch Triangle, Central Artery District, and South Boston. Now, this project does not fall into one of those overlay districts, right?
Right.
So this says, but if a project falls in one of those, and then I will read, the applicant shall demonstrate that the proposed project complies only with subsection B of this section 32-6. For the life of me, I don't know of any way to read that other than to say that if your project falls in another overlay district, then you must satisfy both A and B. Can you please tell me why I'm wrong?
I don't believe that you're necessarily wrong, and I'm not sure that the statute is written is actually, I mean, we're not in dispute that the project meets A and B. We're in dispute to how the judge got there. And the fact that in those particular areas, the only thing that matters is that they prove under section B there's no negative impact. They don't have the ability to rely on the presumption that goes with the installation of a system that meets the requirements as approved by the Boston Water and Sewer Commission. I would also—
Is there any appellate case that sets up this system of presumption that you're relying on?
I don't think that it's a presumption, a statutory presumption, as much as an evidentiary one. Again, I don't believe that the application of these criteria can be divorced from the practical issues on the ground. The point of this is to get groundwater infiltrated into the back bay. To do that, they have determined what the minimum requirement is for a project to meet in order for that to happen. And
well, as I read this section, it looks to me like what has been determined is that an applicant for a project in the back bay must satisfy, and I mean, section 32.6 clearly puts the burden on the applicant, that the applicant must satisfy both A and B.
And
that's
we
the
have
way,
satisfied that.
That's what and now the question of whether or not the same evidence could satisfy both, that's related, but that's a different question. That it seems to me that as a matter of statutory construction, the applicant must satisfy both. Now, it may be that the same evidence can satisfy both, but it seems to me we do need to have evidence on both and findings with respect to both. And with all due respect, I do see the findings with respect to subsection A, but I'm not so sure I see findings with respect to subsection B.
But you do have findings regarding subsection B, and I would like to point out, because I need to say before we leave,
where?
There is also no discussion, there's also no word investigation in subsection B. And to interpret subsection B as requiring some independent investigation, not just of Mr. Perry's property, but of all abutting properties, makes this an impossible statute to comply with. The idea was to get as much groundwater.
Yeah, that's a straw man for the moment. You need to answer Judge Wolohojian's question. Where is the evidence on B? This is what I was getting at as well.
The evidence on B is from Mr. Grassi and Mr. Keeler and Mr. Brewer, who all cite what the requirement is, and that this project is putting water into the groundwater. It can't just be the case. And they also provide evidence that it's not.
Does somebody say this?
I'm sorry, I couldn't hear you.
Somebody say what you're saying. Does
Yes,
some
in
expert,
our brief.
let me finish my question.
I'm sorry.
Does some expert say when you start with everything going into the sewer system and you design a project so that we capture almost everything that lands on the property and put it into an infiltration system, that the groundwater levels will not be negatively impacted?
Yes.
Someone say that.
Yes.
Where am I going to find it?
You're going to find
You
that.
don't have to give me page, and don't give me page, just which experts? Brewer?
Brewer, Keeler, and
Okay.
Grassi. And Mr. Grassi has also testified, which is unrefuted in this case, and Mr. Perry's expert agreed, that you can't just determine the groundwater from one.
Yeah, but you know.
Okay, I think we're going to have to just check that out because the evidence will be what the evidence will be. I have a question for you regarding jurisdiction. How is it that the Superior Court had initial jurisdiction over the 2017, if I have the date right, proposal?
Because the 2017 proposal as for the stormwater infiltration system was just modifications. It wasn't a new.
Okay, I'm gonna, my question, and it was inartful, is asking you for legal authority. What legal authority is there for the notion that the Superior Court has initial jurisdiction over a proposal that hasn't first been submitted to the zoning board?
With all due respect, the proposal was submitted to the zoning board. It was modified. The zoning board was notified of it, as was the Boston Water and Sewer Commission. The jurisdiction comes from the Boston Zoning Enabling Act, Section 7 or Section 11, which is once the ZBA has issued its decision, proper appeal is brought to the Superior Court.
But surely you couldn't have something entirely different go before the court, right? There's got to be some sort of scale on which this is evaluated, whether it's a true modification as opposed to something new.
Yes, and it's not something entirely different. There's evidence in the record to show the system is located on the property. It takes.
Okay, but we're not operating just out of equity or some kind of notion of what it should be. What legal authority is there for, like, where's the line? What tells us when the Superior Court can do this and when it can't?
Well, there is case law. I'm sorry you don't have it handy, but there is case law that allows the Superior Court to allow and define evidence as to modifications made, that at the end of the day, if the ZBA would find the same thing, there's no reason for it to have gone back before the ZBA. The Boston Zoning Enabling Act specifically provides jurisdiction to the court.
Yeah, you didn't cite any of those cases in your brief that say what you just said. I did read cases that say the court is not limited to what was before the Board of Zoning Appeals. That,
yes,
I think, is unequivocally the case.
Yes.
Based on SJC decisions going back to the 50s. However, how you would draw this line, the statement you just made, which is that it doesn't have to go back. I didn't read any cases about that, or any cases that address modification, or anything that helps us. Are there cases?
I think that you'll find those cases and an analogous analysis in the cases that discuss when a court is required to remand a decision to the board. And in this case, the judge expressly discussed that. He said there's no reason for a remand because the evidence shows that they were entitled to the conditional use permit, that remanding it would only result in the same thing. I mean, he did analyze that question directly. And I think the jurisprudence concerning the ZBA's or the court's ability to remand or otherwise not remand sweeps this issue indirectly.
Okay, thank you very much. Your time has expired. I'm just going to look to see if there are any further questions. If not, thank you both for your arguments. The case is an interesting case and we were helped by both of your arguments. So thank
Is your name in your window?
Yep.
And we are live.
Good afternoon and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format due to the ongoing pandemic. Although we are conducting court in this way, all the ordinary rules of oral argument apply, including that each side receives 15 minutes to argue with no rebuttal. I'm now going to call two paired cases. The first is Kathleen Fisher versus Presti Family Limited Partnership, case number 2020P0611. And the second is Presti Management Corporation versus Edmund C. Tarnuzzer Jr., case number 2020P0696. The appellant in both cases is represented by Attorney Bobrowski, and we are ready whenever you are, sir.
Thank you, Your Honor. If it pleases the court, I'm Mark Bobrowski. I represent Kathleen Fisher in both the Land Court and the Superior Court cases. My office is in Concord, Massachusetts. This is a case that is in a newly emerging line of cases having to do with the ability of a neighbor and a butter, a person aggrieved, to seek zoning enforcement from a building commissioner. There's very little appellate guidance as this case emerges. I fear that it may be another slippery slope in the area of zoning enforcement. The pattern here resembles very closely the pattern in Gallivan versus the Board of Appeals of Wellesley, in which the court now has seen a number of cases develop that line further down the slippery slope. This case, in my opinion, can be decided on the basis of three documents, and those three documents are the April 7th letter of Ms. Fisher to the zoning enforcement officer of Stowe. She repeated much of that in her May 22nd letter of 2017, and finally the building commissioner responded to both letters in his May 26th, 2017 letter. The question here is whether or not Ms. Fisher requested zoning enforcement, and if indeed she did, the scope of that enforcement, and lastly, whether or not the building commissioner adequately responded to those enforcement requests with a denial which was sufficiently definitive, to quote Judge Shire in the standard that she enunciated in a land court case.
Was the issue of jurisdiction raised before the ZBA?
No, in fact, the building commissioner, after she failed to appeal by June 26th, the May 26th letter, reviewed the matter again, and after she prepared another enforcement request, he denied it, and the matter was then heard by the full Zoning Board of Appeals in the fall of 2018, resulting in the two appeals that are before you today.
Can you give me any?
Sorry, go ahead, Judge.
Can you give me any insight into why were the town defended on the question of jurisdiction down below? It has not appeared now on appeal.
I think, Your Honor, I represent municipalities quite often, and my instructions are usually to let the private parties fight it out rather than incur municipal expense. So I believe that's all you should read into that here.
The town took the position down below that it was going to defend the decision that the board had made, right?
Yes.
And they're a defendant in at least one of these two cases, right?
I believe in both.
Okay, and they have not appeared.
Again, I don't read anything into that, and I know town council other than her determination that town's resources are best saved by letting the private parties argue it out.
So back to the question Judge Wolohojian asked you off the top. when the case was argued before the Zoning Board of Appeals, did Presti take the position that the court lacked jurisdiction because the appeals were untimely?
To the best of my recollection, the answer is definitively no. That was not raised until Attorney McLaughlin came onto the scene sometime down the road. And remember that the Hudson versus Beelan case, which is the basis for my brother's responses here, was not decided until the very end of 2018. I believe the date was in December of that year. So that case really was not on anybody's mind when.
Well, but the 30-day requirement's been in the statute and it's been construed for years.
I understand that.
But not in this particular context.
No, so if I could prevail upon the court to just consider addendums 2, 3, and 4, which are attached to the rear of my brief. Those are the 3 documents I alluded to earlier. In addendum 2, which is her first enforcement request, and remember, throughout this entire matter, Ms. Fisher was pro se. She did not have guidance of counsel. She had no lawyer. She didn't have a lawyer until well after the appeal period expired for the May 26th letter. So this is all being done on her own. And in that first letter that she wrote on April 7th, she said, she asked the building commissioner to cease the commercial traffic and noise that was being discerned on the Presti property. There are excerpts from that I've included in my brief on page 13. She also asked the town to enforce the zoning bylaw on Mr. Presti's properties. Please issue a cease and desist order for the commercial traffic being generated along my property. There's no doubt she used the word enforcement, and there's no doubt that she used the word cease and desist. But
do you think the interpretation of these letters is a question of law, a question of fact, or a mixed question of law and fact?
I think it's a mixed question of law and fact. The judge viewed her use of the terminology here to be sufficiently compelling that he ruled that this was an enforcement request, and he invoked the Hudson versus Beelan holding in throwing in eliminating the case on the basis of jurisdictional defect.
That really wouldn't matter, right? I mean, you could still prevail even if you lost your view of those letters, even if those were enforcement requests, if the response was not an appealable decision, correct?
I agree, Your Honor. So in the second letter, and if you, again, the model, it's not a model of clarity to look at the April 7th letter. By the end of the first page, Ms. Fisher is talking about fences that have been knocked down and plowed and broken in, and when the snow melted, the fence collapsed. The building inspector certainly never even addresses those issues. The May 22nd letter more or less repeats the same themes. Again, she asks in the very first line, stop the commercial traffic growing and increasing on the Presti property, issue a cease and desist order on commercial activity on these properties in the second paragraph. In the third paragraph and the fourth paragraph, she's talking about concerns that she would have expressed to the building commissioner. She saw him on the property with Mr. Presti, and somehow he got away before she could speak with him. And then again, there's some information about the fences. There's, in the last paragraph on that page, information about clearing of the land and trash on the neighbor's property. And by the end of the letter, she is again asking for a cease and desist, as it is clear the commercial use does not belong in the business zoned area. Again, no, we certainly can't undo the words. There's use of the term enforcement and there's use of the term cease and desist.
To the extent that these can be, let's just say, a mixed bag, these letters, right? They're subject to interpretation, perhaps.
Yes.
And we're viewing this in a, does it matter that we're viewing this in the context of a motion for summary judgment?
Well, you certainly don't have the benefit of putting Ms. Fisher on the stand to go into a little bit more amplification of what she might have had in mind here. But I don't.
And his intent is, well, sure, you both admitted that all these letters speak for themselves. So does that mean that intent is not relevant?
I think that the letter speaks for itself is probably the major theme that I take away from this. If Ms. Fisher were on the witness stand, perhaps she would begin to explain the rationale behind using certain words and asking certain questions. But I think the letter is an adequate way of determining what she was asking for. As I
Well,
noted in my,
what was the, I noticed that the town down below took the position that I think it was July 13th, 2010 letter, that was the response to the first two letters from your client, right?
well, he did include an earlier letter, yes.
Well, yes, he included a way back. Oh, no, sorry. I'm giving the wrong date. That the May 26, 2017 response from the building inspector. Right? I'm talking
Yeah.
about that letter. That was
Yeah.
the response to the first two letters from your client. The
Correct.
town down below took the position that that was not an appealable response from the building inspector.
And
that was
consequently went on to have a
not a
hearing.
final decision.
Right.
That was not a final decision. I'm wondering what we do with that assertion in the motion for summary judgment context.
I think that the facts here up to and including June 26th are relevant. What happened after that is evidence that the town reached a certain conclusion with regard to those three letters and the appeal period that was pertinent to them. But I think the case can be decided on the basis of the three letters. And the key point here is the last of the documents, the three documents, the May 26th response of the building commissioner. If this would be my my plea to Judge Speicher, who decided this case at the lower level. If you're going to hold pro se plaintiffs to enforcement requests based upon their use of the words enforcement and cease and desist, let's hold the building inspector responsible for making a coherent denial out of whatever correspondence comes in front of him or her. And I note in this regard that the building commissioner denied the request to stop the commercial traffic on the property by saying, with regard to traffic, I don't have jurisdiction. That's a definitive answer. I credit the building inspector for that, but he addresses nothing else definitively.
Well, no, sorry. He says these types of uses are recognized as grandfathered uses as outlined in my attached July 13th, 2010 letter to Mr. Presti. Now, you know, that it seems to me, I mean, one reasonable interpretation of this letter is, I'm not going to take any enforcement action. These are grandfathered uses. What's wrong with that interpretation?
I don't believe that if you look at the May 22nd or the April 7th letters, that's an issue that she raised. So as I pointed out, enforcement requests have been placed by the appeals court into two categories, general and specific.
She mentions use, commercial use in both letters, both April 7th and May 24th.
But I view that in the context of her complaint about commercial traffic. It's just another way of saying stop the commercial traffic. The key for the building inspector is that nowhere does he use the word deny, other than to say that he doesn't have jurisdiction over the traffic complaint. And nowhere does he say that this is an appealable event pursuant to Chapter 48, Sections 8 and 15, which is the next step if it's going to the Board of Appeals. And that's customary by building commissioners across the Commonwealth.
Is there any requirement that it include that language?
No, there's not a requirement, but it's good practice on the part of the majority of building inspectors will do that. Instead, what does Mr. Martin say in his letter of May 26th? If you need further information, please contact me at my phone number. That's not a denial. That's let's talk some more if you've got a problem about this.
I find that you are arguing that the letters must be construed as a matter of law, contrary to the way the judge construed them. And I'm going to have the same questions for your brother, but I'm struggling with the question of why the interpretation of these letters is not a question of fact that simply cannot be resolved on summary judgment. The letters are subject to interpretation. They're not unambiguous, it looks to me. Certainly the judge's construction was a reasonable one. I don't know that it was the only one. And I'm wondering what you have to say on the relationship between the summary judgment standard and the interpretation of these letters.
Well, certainly on summary judgment, we only have what we have to work with here by way of exhibits and affidavits, none of which are attached. No affidavits, at least. On trial, the letter could be placed in the hands of the witness and further explanation could be probed and offered. I think it's a determination as to whether or not the facts were sufficient in the mind of the judge to avoid the need for a trial on point. I certainly did not argue that we could not proceed on summary judgment in my brief. And I'm not persuaded that that's the case today either.
All right, so you just think that as a matter of law, these letters must be construed in the opposite way than the judge construed them.
Particularly the building commissioner's letter. I mean, Judge Shire, Chief Judge of the Land Court, had an earlier case, which I cited in my brief, and she said that the building inspector's responsibility was to be sufficiently definitive. I dare anyone to say that the letter that Mr. Martin wrote on May 26, 2017 is sufficiently definitive.
What letter is sufficiently definitive? I'm looking through these and I can't. Where does he say I denied?
He doesn't.
Well, in a subsequent letter, he does say, look, you know, if we reach the end of the road, you can appeal.
But by then the appeal period has expired and she's still without a lawyer on that day.
But when he says that if you don't, if in the end you do not accept my conclusions, you may appeal. Where do we have a conclusion?
The end.
Well, finally, what happens is that there's another more cogent enforcement request citing the bylaw violations by chapter and verse. He takes that up and he kind of gives half of the victory to Ms. Fisher and he gives another half of the victory to Mr. Presti. That's ultimately what makes its way to the appeal before this court.
All right, let me see if there,
I'm sorry.
let me see if there are any further questions.
Are there any other abutters?
None that were participants in the litigation.
But there are, I assume there are other abutters to the property?
Oh, certainly, Your Honor. Yep.
Did they get notice of the board's hearing?
Yes, they did. And some of them did appear at the hearing.
All right, I see your time has expired. Thank you for your argument. We'll now hear from Attorney McLaughlin.
Good afternoon, Your Honors. Robert McLaughlin, Senior, Florida Family, Presti Family Limited Partnership, the appellate. At the outset, I disagree with Mr. Babowski that this is a new involving area of the law that is a slippery slope. Although there's no requirement to file an answer as far as the private plaintiff in the zoning case is concerned, I chose to file an answer because I wanted to assert the affirmative defense of lack of jurisdiction in that issue we're here. In my cross appeal in the Superior Court, I laid out the whole issue of jurisdiction. So this is nothing.
Was it raised to the ZBA?
I was not attorney at the ZBA, but I agree with Mr. Babowski. I don't think it was.
Okay.
So what does that matter?
No, I don't think it matters at all.
Why? Because you think this is a matter of subject matter jurisdiction for the board?
For two reasons. First of all, it's very interesting that the attorney for the town of Stowe, who actively joined with Mr. Babowski in the lower court decision and so forth, she chose not to appeal, which raises kind of an interesting question. I argue, or would argue, if this appeal is ever upheld and this is reversed, I would argue that the town of Stowe has accepted the fact that they didn't have jurisdiction, didn't appeal that finding of the appeals court, and it would be res judicata between Presti and the town of Stowe.
So ordinarily, when we review a decision on a motion for summary judgment, which this was, it is as though the lower court's decision didn't even happen because it is de novo review of the summary judgment record. And here, we've got in the record these letters, which everybody just seemed to submit to the court saying they speak for themselves. But we also have an assertion by the town that the the building inspector's letter was not a final response or determination subject to appeal. How is that not a disputed issue of fact, or at least it's fact dependent, it seems to me, as to what the meaning of these letters is?
Well, Your Honor, please, first of all, I think a letter, unless it is ambiguous, is absolutely to be determined as a matter of law.
Okay, so why are these, at least why is the building inspector's May 27th, I get the dates wrong, I'm sorry, but the first letter back from the housing inspector, why is that not ambiguous?
He says, I received your letter requesting cease and desist action to stop commercial traffic on the Richard Presti property. These types of uses are recognized as grandfathered uses as outlined in my July 13, 2010 letter. So he incorporates that by reference. And what does it say? It goes on, the July 13 letter. It is my determination. How clear can he be? It is my determination that these types of uses are the same or consistent with past uses on the site, recognized as grandfathered uses by the zoning board of appeals.
Okay, so the town, so council, the town says on the appeal to the trial court, we didn't mean that to be a determination. That should not be read as a determination. What do we do with that? And I'm going to compound my question by saying, particularly under circumstances where the board took jurisdiction over an appeal, and there was no objection by your client at that time to the board taking jurisdiction.
If there's one thing that is very clear in zoning, is that the trial court, land court, or superior court hears the whole matter de novo. And so the jurisdiction question, whether it was not raised at the lower level, I don't think is important at all. And you look at the decision, jurisdiction can be raised at any time. And
well, whoa. Subject matter jurisdiction of a court can be raised at any time. Do you have a case that says that this word jurisdiction, which gets misused constantly, can be of the board when there's no objection to them taking the appeal, that can be raised at any time?
I believe it can, Your Honor. If they had no jurisdiction and then purported to make a decision, that's something for a court to decide. And the court did decide it because I raised the issue.
No, we're not saying that a court doesn't have the authority to decide that. We're just saying, can it be raised in the first instance if it's not subject matter jurisdiction once you get to the court?
I submit, Your Honor, it can. And of course, I don't have a case on the tip of my fingers right now. But let me point out one other factor, Your Honor. The June 8th response by Ms. Fisher, which is in the record 93, page 90 to 97. In that letter, she says, I received your response regarding the cease and desist activities that have increased and is against the town zoning on Mr. Presti's property. I was shocked in your letter that you grandfathered the uses of the Presti properties. She didn't misunderstand anything. She knew it was denied. And that's part of the record. Now, let me go on beyond that, Your Honor. The counsel's letter, I call it the Hail Mary letter, trying to reset the clock, goes on reciting in the 5 previous letters, specifically, Ms. Fisher's correspondence requesting zoning enforcement of all current uses by all the tenants of the property. We have his pleadings in paragraph 18. He says, and he's bound by his pleading. He said, requested the building inspector to issue cease and desist orders. And now on the issue we're talking about, paragraph 20, the building inspector opined that all these uses were grandfathered as lawfully pre-existing non-conforming uses. That's the law of the case. He's bound by chapter 231, section 87.
Well, surely the town wouldn't be bound by that. You've got to go to your last argument is the only argument that's going to get you there. The one where you said, well, the town didn't appeal, so maybe they're bound because.
That's what I was about to say, Your Honor. The town took the position. As a matter of fact, at the trial, it's not in the record that Mr. Babowski was there. I was there. When town council was arguing that, well, gee, maybe the building inspector's letter isn't clarified, Judge Spicer interrupted. I'm surprised to see you arguing that. And then she sought not to appeal it. So I think that issue, if anyone waived anything, she waived that issue. Certainly as much as.
If we were to conclude that these letters were ambiguous, what then?
If they were ambiguous, it wasn't raised at the trial level or at the hearing on the motion of summary judgment by Mr. Babowski. As a matter of fact, as you pointed out earlier, both counsel have taken the position in this case. The letters speak for themselves.
Sure, but that's a different issue. Ambiguity is determined as a matter of law. So that is something that we would be looking at in the first instance.
Then, Your Honor,
if we looked at it and we said, these letters are ambiguous, what then?
part of the, well, if you say they're ambiguous, I would ask you, first of all, not to reach that decision in the light of what I just argued. Her June 8th letter, she certainly understood what she was asking for. I was shocked that you didn't, let me read.
But I'm worried about set aside the appellant's letters. I'm more concerned, frankly, about the building inspector's letters. If we were to conclude that the letter was ambiguous.
If you conclude that the letter was ambiguous, then
yes.
I suppose that in a motion for summary judgment setting, you're finding there was a material fact that was in dispute.
And then it would go for trial on that issue.
I would ask Your Honor again, to look at, he incorporated by reference what I read in his June 13th letter.
Sure, but there are other portions of the letter too. We've all read these letters.
Well, let me say this, as far as talking about commercial traffic and so forth, any appellant has to show they have standing. It's very common. They're going to talk about noise and traffic and her broken fence. All of those are expected to be in an zoning enforcement request. They're required to be there. They're required to have standing at the ZBA level. So that you don't take the fact that those are also in the request and misread it when so clearly she's asking for there be.
Yeah, but you see, you're still focused on what she said, and Judge Wolohojian is asking you about what the building inspector said. And I think, and I'd like to hear your thoughts, counsel, that the answer to Judge Wolohojian's question may be, the case law says that there has to be notice. There has to be notice sufficient to trigger your obligation to file within 30 days.
The case.
Let me finish. And if we were to conclude that this was ambiguous as to whether the building inspector actually had issued a denial, then I think the question would revolve around whether it's sufficient notice. And then I would add to that, what relevance does the board's position taken below have to that? Because the board says, we don't think the denial was a denial.
Well, two things. The ZBA below didn't even think about this issue. And Mr. Babowski's right. I thought about it when I first saw what happened, that they were trying to reset the clock and the building inspector.
Respectfully, I don't think that helps you, but we'll get past that for now.
Let me just say, I don't think when it incorporates the June 13th letter, the July 13th letter of 2010, in which it just cannot be more. They recognize as grandfather uses, and when you are construing it, if there's any factual dispute, you take her June 8th letter, in which she comes back and she says, I received your response regarding the cease and desist. I was shocked your letter that you grandfathered. So there's no ambiguity here. And when we come to the There's no ambiguity. She had no problem understanding, and she still had 24 days. No, she had about 2 weeks left to appeal. And there are cases where people have sought enforcement orders on building permits. And the law on the building permit, if you're a neighbor or have standing and you think that it violates the zoning law, if you know about it, you've got to appeal in 30 days. If you don't know about it, you can't bring an enforcement order if you had even constructive knowledge of it. The zoning law is very harsh. Land is only as good as the value, and there has to be some certainty in it.
But there's a difference between a building permit and a use problem, isn't there?
Well, it depends what the issue on the building permit is. My point is, as far as neighbors are concerned, they're held to a standard that they have a duty to protect their property.
Surely she had no obligation. So she's writing things in her early letters that suggest to me, at least, that she hasn't had a tour of your client's property. If somebody's got big fences up around, you don't know whether they're violating the zoning laws. In terms of use, as opposed to building permits, which have to be filed with the town.
Your Honor, she knew exactly. She lives right next door, and there's a fence, but she drives by it every day. It's from the public way. It's very clear. The buses are there, the construction.
None of this is evident from the record.
I agree with you, but she has the burden of showing she has standing, and I think she has standing because she's.
Well, standing wasn't argued in this summary judgment context. All we've got is the issue of whether or not the appeal to the ZBA was timely.
And that's the issue, and
That's the
I haven't
issue.
challenged standing, but I absolutely challenge the fact that it is very unsettling that a building inspector can respond and come back and say they're grandfathered, and if she comes back and says, I'm shocked, and to now say that that wasn't an opinion. Matter of fact, the law is not that the word denied gets used. Mr. Rabowski agrees to that. The word is the decision of the building inspector tantamount? They use the word tantamount. I forget the case that uses it, but is it tantamount? It is very clear that that was tantamount to letting her know, I don't agree with you, Ms. Fisher. So that it's.
You know what's unsettling to me? That the board had a hearing where nobody objected to its jurisdiction. It said several of these uses are violations of our zoning laws. And your argument, which is, I don't blame you for making it, obviously, which is based on what the trial court said, is that there's no recourse with respect to that. Your argument is forever she's barred as long as the uses don't change. I assume you would grant me if the uses change, she'd have another shot.
Your Honor, the zoning law is replete with harsh results if you don't obey the rules. The people who appeal a zoning variance 21 days or misfiling in the town clerk's office, there are thousands of cases where you don't touch all the bases in zoning, it's fatal.
And many of those are based on the notion that once a structure goes up, you don't, there are sunk costs that you don't want to undo. And so you want people to act quickly. But I'm wondering whether use is a different animal.
I don't see that the use is a different animal. I don't think there's two paths for procedural process in the zoning bylaw. I mean, you have rights under the zoning bylaw. And if you're aggrieved, you follow the rules. And being repetitive, oftentimes very harsh by just failure not to have a certified copy of the decision attached to your complaint. I mean, there are minor things, but that's all part of an integrated statutory scheme that the real estate community has to rely upon, and finance people have to rely upon. If somebody hasn't asserted their rights, you have a right to assume that's the law of that property now. And it's very slippery slope if there's a change in that.
We're going to have to leave it there because your time has expired. Let me just see if there are any further questions. I don't see any. Thank you both for your argument. It's a very interesting case. and we've been helped by both of your arguments, which were ably presented.
Yeah,
With
well
that-
argued on both sides.
Yep,
Thank you, Your Honor.
with that, we're going to take the case